Good afternoon, everyone. Today is February 24th of 2022. It's Thursday, and we're convening a tax review board session for license and inspections. My name is Melissa Andre. I'm the executive director of the board, and please be aware that this is a public meeting and it is being recorded. Because the meeting is public, participants and viewers have no reasonable expectation of privacy. By continuing to be in this meeting, you are consenting to being recorded. I also want to note that Nancy is the chair, and Nancy, please take it away.
You're ready for me to go?
Yes.
Okay, thank you. Good afternoon, everyone. This is the Tax Review Board hearing for February 24th, 2022. We are ready to start with item number 1 on today's agenda, which is Philadelphia Lotus 6 LLC, last 4 digits of the docket 9258. I believe that the parties involved in this are in the room. If you would, please identify yourselves for the record.
Good morning, all. Lorenzo Di Natale on behalf of Lotus 6 LLC.
And with you?
Omri Shitrit, representing Philadelphia Lotus 6.
And are you an attorney also?
No.
No, okay, then please, excuse me, you did identify yourself by name. Do you swear or affirm to tell the truth with everything that comes before the board?
Yes, I swear.
Okay. And
I'm so sorry to interrupt, but I didn't catch his name. Would you repeat your name, sir?
My name is Omri Shitrit. It's O-M-R-I, and my last name is S-H-I-T as in Tom, R-I-T.
And your relationship to the petitioner?
I'm working for this company.
You're an employee or a partial owner, something like that?
Correct.
Okay. And in terms of the attorney, if you're comfortable being without the mask, we would, it makes it easier for us to hear, but if you're not, we understand. And we ask both of you when you're talking to be as close to the computer as you can be, because that's where the mic is located as well as the camera. And so we hear it best when you're talking closer to the screen. Who has this matter for the city?
I believe it's Ms. Curley.
I'm looking for someone to be coming on and identify.
I'm so sorry. I joined late, so I didn't hear the matter called. I'm so sorry about that. I do apologize.
Please identify yourself for the record.
Caroline Curley, C-U-R-L-E-Y, solicitor for the city.
Okay, and do you have others who will be with you that will need to be sworn that are not attorneys?
Yes, I do. I have Mr. Richard Wade, who I see present. I am looking.
I'm sorry, Tom is in building standards and he should be here momentarily.
Okay, please identify yourself for the record.
Richard Wade, litigation support, license and inspections.
Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, thank you. And then we can swear your colleague in when he's here and ready to actually testify. Does the city have any opening comments, and could you include within that any numbers for the record?
So the city can call Mr. Wade for the numbers. Mr. Rebekowski is our primary witness, so we will need him to proceed.
We usually hear from the petitioner and then come back to the city. I'm only looking for opening comments and numbers from the city. And if you have no opening comments, that's fine. It's just that we give the city an opportunity to make a statement, and that's usually from the attorney.
Okay, I mean, we will be asking to fully affirm the amount of the abatement, the cost of interest and administrative fees. The evidence presented today will clearly justify the billing of that amount.
Okay, could we have at least total numbers for the record from Mr. Wade?
Thank you.
Property for the property at 2020 West Glenwood.
No, I'm sorry. This is 1946 Napa.
I apologize. I'm sorry. This is for 1946 North Napa. This is a demolition. The labor, $13,735. An administrative charge, $2,000. $884.35. Interest, $2,357.25. Total amount due, $18,976.60.
Any change with that?
Me?
$18,976, and were there any cents with that or just?
60. 976.60.
Okay, thank you.
Mr. Wade, the bill date?
I have July 2nd, 2019.
Thank you.
Okay. Anything else, an introduction from the city, or should we turn to the petitioner?
I'm finished. Thank you.
Okay, thank you. Please tell us why you're here and what it is you're looking for from this board.
Yeah, sure. Good afternoon, all again. Before I do that, I had a conversation with Ms. Curley prior to today's hearing based on a request from her via email this morning and new documentation coming to light. And what she advised me is she wanted a continuance today to be able to sort what we found out at this last minute this morning. I said I was fine with that. However, these findings need to be put on the record in front of the tax review board. So I don't know if it's her intention to still proceed, but it is my intention to put my findings based on Ms. Curley's request via email to me this morning on the record. And I wish to do that first. And then if we're going to proceed with this, I don't have an issue with that.
To be clear, I am not requesting a continuance. I was able to review the material submitted by the attorney and cross-reference it with my own material. We are ready to proceed today. Thank you.
Okay, so is it your position that you did not ask for a continuance prior to this hearing, Ms. Curley?
No, I discussed it with you, and then I was able to go back, and I know, and you indicated you wanted to go forward, so I discussed it with my client, and I'm ready to proceed. It's fine.
You are ready to proceed?
Yes.
Okay, all right.
If you could keep your voice up a little bit, I can hear you, but it's marginal.
Okay.
Do you
Ms.
mean
Curley,
me? Sorry.
Ms. Curley, you advised pursuant to that conversation that you sent me some pictures via email, which I did not receive. Did you send those to me based on what you represented earlier?
Courts and Mr. Di Natale, I have it that I sent it at 1:01 p.m.
Okay. And let me just check my email. I just want to confirm that.
And if it is helpful, I have supplemented my own exhibits, and I can include that document if that is helpful.
Okay, and you're referring to the demolition pictures from 7/1? Is that what you're referring to? Because that's what we discussed. This needs to be placed on the record for everybody's benefit.
And I have incorporated it into my exhibits and did send it.
Okay.
Did not receive
And did you
it.
send those to the tax review board as well?
I have not. I will obviously, when I present it,
Can
I
you
will obviously
please do
supplement
that
that.
for everybody's benefit. If you intend to incorporate them, everybody should have those now before we begin.
I'll be sharing my screen. They'll see it. And then it should be okay. Does that make sense?
No, I would object to that. I'd ask that you formally send those to the tax review board, please,
Right now. Oh,
right now.
Yep.
Thank you. May I continue?
Yes, please.
Great.
Hold
Okay.
on, just for,
Oh.
excuse me, just for my understanding, you do want to proceed forward today despite the fact that you had a conversation with counsel about a continuance for today? We're just trying to follow what this crosstalk just happened here.
Sure. So it was not my intention to proceed, but because of what I've discovered, it was certainly my intention to put this on the record for the tax review board's benefit and to continue this matter based on the Commonwealth's request. Apparently, she's saying that she withdrew that request or intends to go forward. I still intend to outline everything from this morning's conversation, and then we can proceed from there.
Okay, so we are having a hearing today. Okay, that's all I wanted to clarify. Thank you.
So Mr. Di Natale, why don't you start? Please put on your case, show us your exhibits, tell us what you need us to know.
So I want to start with this morning's conversation with Ms. Curley via email. And I've sent my documents to the tax review
Wait.
board.
Are these opening statements or is this the beginning of testimony?
This is what I am documenting for the record, then we can get into the hearing. I am documenting our conversation and my request to you, an ongoing request to forward the demolition pictures from the alleged demolition date of 7/2, which I have not received, which you have not forwarded to the tax review board. And I'm doing that because I feel those pictures are very important because they are in direct contradiction with all the paperwork that you've presented to me in this matter. And based on your request, what I was able to find out today at the very last minute.
All right, so Mr. DiNatale, you have to understand that as a board, we have not heard any of the facts, any of the timeline. You need to start and walk us through all of it and get to what I guess is the end, which is whatever happened today, because we have no reference for this. So going back and forth with Ms. Curley is not really helping.
Well, I'm not going back and forth. She's an officer of the court. She made several representations to me on how she would proceed today. And
Okay, we got it.
We need to start with the basics though.
So if she's changing that, then fine, but she should say that to everybody ahead of time.
I think she said it, so we can keep going.
Yes.
This is an appeal from a demolition matter of 1946 North Napa Street. My understanding of the facts is that the demolition, well, it was first slated for demolition sometime in 2019. My clients purchased this property at sheriff's sale. So on March 21st, 2019, they bid on the property.
So again, I just want to clarify, is this opening statements or are we beginning the hearing with testimony?
We start with testimony from the petitioner and then from the city. That is our normal practice.
So I'm
This
objecting
is
because
a-
counsel is testifying at this.
No, I am not.
That is what we,
Okay.
This is an opening.
Okay. Let's take a step back. So what it sounds like to me is counsel is giving the reason why he's here. So that's clearly an opening statement. That's
Okay.
what's happening.
All right, just thank you.
After that opening statement is closed, then we will proceed forward with him giving his case in chief. You will have an opportunity to cross his witness, and then it will go back to you. You do your case in chief. He'll have an opportunity to cross. Are we all clear on the rules of engagement here?
Thank you, Ms. Ward. I just wanted to clarify
Okay.
where we were in this process. Thank you so
So
much.
let's do your opening. When your opening is over, please let us all know. So then you'll let us know when you start your case in chief. Okay?
Very good.
Thank you.
As I said, this property was bid on by my client on March 21st, 2019. The deed was acknowledged by the sheriff on May 13th, 2019. On or about May 22nd, 2019, my client, who was advised allegedly on May 21st of 2019 via letter that the property they had purchased was being demolished, visited L&I on the 11th floor in person to explain that they intended to address the issue. The government's paperwork shows that there was an agreement to put this matter on hold so that my client could address this issue by filing permits, by doing whatever he needed to do. My client showed the person at L&I an engineer's report, which we have as an exhibit, slating the property was not deemed to be in danger of imminent collapse, but that he was willing to remedy the problems and filed for permits. My client attempted to file several permits during that time, all of which were rejected. They were rejected because there was no way to verify ownership. And that is because the deed had not yet been recorded. So on or about June 5th, 19, they engage an attorney to file a TRO, temporary restraining order, an injunction to stop the demolition of the property. The attorney files this and never serves it. And they never serve it because at that time, the property was demolished. Okay? Now, we intend to prove the city's records are inaccurate. They contradict each other. And our position is simple. 2 weeks to resolve this problem, less than 2 weeks, on a property that they are an equitable owner. And under the law, an equitable owner doesn't even have to do anything to the property until the right of redemption is over, is patently unreasonable. They demolished this property with improper notice. Essentially, what this is it's an unlawful taking, is what it is. And we have case law on that. There's plenty of cases to that effect. But the point that's really concerning is the inconsistency of the documents and the allegations from the city that this property wasn't demolished until July, which we now know is false. And we ask that based on these inconsistencies and the inability really to know which of these documents can be relied on and which can't, in addition to this being inequitable, to charge my client for the violations that are not any fault of his own and he was not advised of at sheriff's sale, is inequitable. And based on this, we ask that you abate the entire interest and principal on this matter.
Okay. Any questions from board members for the petitioner?
Not at this time. Are you going to move forward now with your, with the evidence, testimony and documentation?
Oh, that would be me?
Yep,
Yes.
I will.
thank you.
And I believe we have Richard Wade present. Is that correct?
He
We see-
was, but right now we're hearing from you, and any follow-up when the city testifies, then you have the opportunity to cross-examine the city members.
I intend to call Mr. Wade as of cross, please.
Yes.
That's unusual, but I guess yeah, I'll leave it to some of the attorneys to tell me whether or not that's okay.
Yeah, he's calling him as a hostile witness. That's fine.
Okay. Just wanted to be sure that I would, since I'm not an attorney.
Mr. Wade, good afternoon.
Good afternoon.
Could you tell me what you do for the city of Philadelphia?
I work for the litigation support unit of license and inspections.
Okay. And what is your function there?
I'm basically a liaison between the tax review board, municipal court hearings, and court of common pleas between the law department and the inspectors.
Okay. Have you reviewed the paperwork in this case?
Just the bills.
Just the bills?
Yes.
Okay. And what can you tell me about those bills? Are they accurate?
As far as to the work that was completed, or the amounts and the date?
To the amounts and the dates of the work?
Yes, the bills are accurate as to what is reflected in the City of Philadelphia agency receivables.
Okay. And do you do any due diligence to check the accuracy of those records?
Object. Can he just clarify what he means by due diligence?
I think it's a self-explaining term of art.
I mean,
Due diligence is I'll put it another way. Do you do any homework to make sure that what these contractors submit is accurate?
As me personally, I do not.
Okay, so then how do you know those records are accurate?
I guess I don't know.
Okay, I have no more questions. Thank you, sir. Next, I'd call as of cross.
No, I have an opportunity to ask on direct
Oh, okay.
with your witness.
Sure, go ahead.
Richard, Mr. Wade, my apologies. Can you explain what the process is when you review the bills for demolitions?
Okay, the bills for demolitions as opposed to a tax review board appeal?
Just, no, for a tax review board appeal. What is it? What exactly step by step do you do?
Okay, basically I just pull the bills I pull the bills for the agency receivables and calculate the current interest, break it down into the labor, break it down into principal or labor and administrative charge. For other cases, non-demolition cases, I do check the accuracy of the bill as to the work performed. However, for the demolition cases, Inspector Rabakowski, it's more his area of expertise. So with seal, clip, reinspection fee type bills, those are the cases I do verify the amount of the bill as to the appeal.
Okay.
As far as demolition, Inspector Rabakowski handles those mostly by himself or with his staff.
Gotcha. And so when you come to prepare for today, what is the process that you
My
go
process is I provide the current reflected amounts owed in agency receivables I provide that to Inspector Rabakowski, to which he confirms the work completed, the bill that was the bids and actual winning bid and bills to the agency receivables. If there is any discrepancy in that, that would be dealt with prior to this hearing.
Okay, and that would include you calculate interest on this bill,
Yes,
and you reflect the admin fee that's reflected on the bill.
yes.
That's your singular purpose for these hearings.
For the demo, yes,
Okay, everything else is with the supervisor, Inspector Rabakowski.
yes.
Okay, and the bills are stored where?
And for City of Philadelphia, agency receivables is the amount due, and the actual bill, I believe, is sent out through the Eclipse system and is now kept in that course of record.
And the Eclipse system, just to be clear for the record, is LNI's internal and external document system.
Yes.
Okay. And that's it, nothing further.
Briefly, so your last words to me were, you don't know if those bills are accurate. Is that still your position, sir?
An object is asked and answered.
We have loose rules of evidence here at the Tax Review Board, so your objection is noted. But at this time, the witness can answer the question.
It's my testimony that the numbers I read are what the city has showing in agency receivables. It is Inspector Rabakowski's testimony that will verify that those numbers are accurate to the bills that are sent out through the Department of L&I.
Okay, so again, to confirm, you have no idea if those numbers are accurate.
Counselor, we're going to move on. He
Yes,
already answered the
that's
question.
enough. Thank you, Dominique.
Yeah.
for helping.
He directed
Asked and
you.
answered.
He directed you to the other witness that the city is going to call.
Very
So
good.
we
Very
got
good.
it on the record. Thank you.
Thank you. At this point, I'd ask to call as of cross Thomas Rabakowski.
Has he come in?
Yes,
the-
he's in the room.
He needs to be sworn, Nancy.
I know, I didn't know if he had arrived on the scene. I can't tell from my screen.
I'm here.
Okay, please identify yourself for the record.
Thomas Rabakowski, City of Philadelphia, License and Inspections, THOMAS, RYBA, KOWSKI.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes,
Thank you. Okay, now you may proceed.
Sir, good afternoon. How are you?
good. How are you?
Good.
Been a long time. How are you?
Yeah. Good to see you. I'm well, thank you. Were you involved in the case of 1946 North Napa Street?
Very,
I'm sorry?
very.
You were, okay. Can you tell me when the first notice on this case was sent to my client regarding demolition of the property?
It was hand delivered to his representatives on May 22nd, 2019, when they came up to the floor, when they came to the MSB to inquire about the property. In fact, we had placed the property out to bid the day before. We placed that demolition on hold and advised the representatives of your client to obtain the necessary permits for the repair or the demolition of that property. We gave the stipulation that we wanted a permit under review and in the department's hands by June 5th of 2019, or the city would proceed with the demolition.
Okay. And if I'm correct, and I just want to make sure I heard you correctly, you hand delivered that notice on May 22nd?
There were two
2019?
representatives. There were two representatives that came up to the floor. One was by the name of Zach, who had previously came to the property or came to this department multiple times for multiple properties. And the other one, if I remember correctly, her name was Stephanie, but forgive me. It was a younger, I don't like to but it was a African-American female that represented the company.
Okay. And one of the individuals you mentioned, do you see that individual next to me today?
Actually, no, not at that time, but I did have conversations with your client who sits to your left, or actually to your right. I had conversations after the property had been placed to bid and instructed them to file a TRO to stop the demolition.
Okay. So is it a normal procedure for a homeowner to just walk into the 11th floor to address an issue on his own?
And I'm going to object for speculative. Mr. Rebekowski can't testify as to what is normal.
He
Noted.
works there, he could certainly testify in his experience, whether he sees homeowners coming into the 11th floor every day, every week, every other day.
I'd like to answer.
What did you say?
To the best of your knowledge, Mr. Ribikowski.
Sure, multiple responsible parties of properties come into the building or make appointments to file and obtain permits for the repair of their property or demolition of their property.
Okay, great. So is it correct if I say they came in on their own because they heard this property was getting demolished, or did they have a notice in their hand that they showed you, hey, I got this notice?
No, actually, ironically, the representatives for your client came in as they acquired the property for sheriff's sale. As I know that the properties go out to bid that day, or I knew that this property went out to bid, we recognized the address when they asked for it. That's when I proceeded to print out the notice. I hand delivered it to your representative by the name of Zach and instructed them that we would place the demolition on hold as they were just became the owner of the property via sheriff's sale. I instructed them that they needed to get a permit under review by the department, again, by June 5th of 2019, or we would proceed with the demolition.
Okay, so your deadline was June 5th of 2019, correct?
Correct.
All right. So in between that, did you have any more contact with any representatives of Lotus 6 LLC?
Not that I'm aware of.
Okay. Were you aware that permits were being filed but denied because the city could not confirm home ownership due to lack of a file deed in the system?
The only permit that is in our system, their only permit under this property that is in our system is a permit that was filed on June 7th, 2019. And this permit was an easy alteration permit for this property. Unfortunately, that was 2 days after we had already told the contractor to start the demolition. So with that being said, we had already awarded it, already told the contractor to proceed with the demolition. We moved ahead with the demolition. The appellant or the person sitting to your right did come up to the floor on the 7th. They were instructed to file for that TRO. I do not know what was the rendering of the court in that court filing, but we were never served. A court hearing never took place. We proceeded with the demolition accordingly, and the property was demolished.
Okay,
The permit that was filed on the 7th was, again, it is an easy alteration permit. Under the terms of an easy alteration permit, no structural repairs can be done under an easy alteration permit. This property was deemed eminently dangerous. Structural repairs were definitely required for this property.
understood. Were you aware of an engineering report that my client showed you showing the structure was not imminently dangerous and that there was ample time to obtain a permit to do the repairs?
I never reviewed an engineer's report.
Okay, so it's your testimony, you've never personally saw it.
I saw a engineer's report attached to your evidence packet predating today's hearing, but I never was hand-delivered a engineer's report by your client.
Okay, so under your advice, you told my client to file a TRO, is that correct?
I cannot give legal advice, but I said that the demolition had already been instructed and already is proceeding. He can file a TRO if he wants to.
Okay, and on what day did you instruct my client with that advice?
June 7th, the same day that they came and tried to apply for the permit.
Okay, and what day did the demolition occur?
The notice for the demolition to proceed was June 7th or June 5th, exactly the same as was instructed.
And when did the demolition occur?
The demolition, well, when we awarded demolition, the contractor has 30 days to start and continue that and complete that demolition. So technically, we gave the contractor that they could start on June 5th. They can start anytime after that.
So when did they do the demolition?
If you give me a second, I can tell you when they started the demolition, but I know that permit that was issued by the department accordingly has that the final demolition took place on July 2nd, 2019.
Okay. And what, so let me back up. So this was designated an imminently dangerous structure, is that correct?
Yes,
Okay, what's the protocol for an imminently dangerous structure?
I'm not sure that I followed that question.
So somebody notices a structure is imminently dangerous, that it's reported, however it comes to your attention. What's the next step?
The next step is to serve notice on the owner, whether we
Okay.
post the property or whether we deliver a notice of violation to the owner.
Okay, and in this case, was the property posted?
Yes,
When?
May 7th of 2019.
Okay, and at that point, was my client the owner?
I don't have a recorded deed. As I know that in a personal conversation with your client or client's representation, it was made reference that they acquired the property on or around the end of June or the end of May of 2019.
Okay, and so it's fair to say my client would have never received that notice, and as you stated, he came in on his own, and that's when you handed him the notice on May 22nd, correct?
They would have not had a formalized letter by the department, but the property was posted. So if he was looking at this property to purchase it, he would have saw the posting.
Okay. Now, not particularly pertaining to this case, but L&I procedure. The property is designated imminently dangerous. You post it, correct?
Yes,
All right, what happens next?
we have to re-inspect, well, no, the notice is going to the owner. The owner has the right to appeal the violation to, or they can obtain the necessary permits to make the necessary repairs or demolish the property.
Okay, and how much time does the owner have?
Actually, the posting says you have to obtain the permits immediately.
You had, okay, the posting says that,
Yes,
We know
so
my
does the
client-
notice of violation as well.
but we know my client didn't get the posting. So what does the next notice say?
The next
I
notice.
am
is
just
the
going to
one-
briefly, and I understand the board is going to hear this. I am going to be objecting that this testimony is largely irrelevant. We're here for the purpose of the validity of the bill. This is not a hearing to relitigate whether this is an ID property. It's literally just to debate the bill. So this is all irrelevant, but I understand this is just an ongoing objection for the record.
Very good, thank you. So what does the next notice that my client was handed say?
The next notice that your client was handed was the notice of violation instructing them to obtain the necessary permits for the property.
And the necessary permits would be to do what?
Either repair or demolish the property.
Okay, and to obtain those permits, there'd have to be some record in the system of the owner, because without those permits wouldn't be approved, correct?
No, they can come in if they have the HUD sheet or documentation that they are now the owner of the property, the department will issue them a permit.
Okay, so they would have to have, well, a sheriff doesn't issue a HUD sheet. You'd have to have something showing ownership, like a deed?
You have to have either the agreement of sale that they are handed at the time the transaction takes place, that you are now the owner of the property.
Okay. I'd like to draw your attention to your indulgence. Let me just see what the government's exhibit is here. All right, we have a bunch of pictures on June 7th, and it's marked Government Exhibit G 1 through 10. You have those in front of you, sir?
You said June 7th?
Government's Exhibit G as in George, 1 through 10. You have those in front of you?
No,
You don't have those in front of you?
no, I would ask if they were present, if they could be shared with the screen and with the board.
Okay, let's try to move this along and make it quicker. Do you have a timeline of what happened in this case in front of you?
Yes,
Okay, fantastic. Now, on June 7th, what happened?
June 7th, your client applied for an easy alteration permit on this property. That was subsequently rejected by the department, as the property had already been placed out to bid for demolition, and it had been awarded to our contractor. Your client was advised to go file for a TRO. I went out to the property and took pictures of the property on June 7th of 2019 in anticipation of a TRO filing, as I am also the court liaison for the department.
Okay, and it was that day that the property got demolished, correct?
No.
No, the property was awarded on June 5th.
Okay,
When the contractor starts that demolition is up to them.
so the contractor does it, is it your testimony the contractor does it piecemeal?
Does what?
Is it your testimony that the contractor demolishes these properties piecemeal, meaning a wall comes down today, the back comes down in a week, things like that?
The department has under the master demolition program, the contractor can have the demolition completed within 30 days. How they complete that demolition is on them.
Okay, so you have no,
Can I jump in here? I think primarily we're interested in what happened at this property. Whether or not other demolitions happen in other ways is really not useful for us.
understood. What happened at this property? Was it demolished a little bit at a time?
I can't speak to that. Again, the demolition was approved for the demolition to start after June 5th.
Okay. So
The demolition was told to commence as of June 5th. The contractor has roughly 30 days from the time the bid was awarded. So the bid was awarded May 22nd. So technically, the contractor has 30 days from that moment. But being that it was placed on hold, they would have 30 days to complete that demolition This demolition was completed July 2nd of 2019.
Okay. Do you have any idea why the TRO was discontinued on June 7th?
You would need to advise or contact the attorney who never filed the case.
So they never filed the TRO?
I never had a hearing for a TRO, so you would need to consult that attorney.
Understood. When was the final, since you're telling me they could have started this demolition anytime and ended at any time, when was it completed?
The final picture and approval for payout was done July 1st of 2019 by the area inspector. The final documentation and submittal for the permit was and completion in our system was July 2nd when the permit was final.
Okay. And if we had paperwork showing by the construction company, the final demolition occurred on July 2nd, 2019, would that be correct or incorrect?
I just said the demolition, the permit was finalized on July 2nd, 2019.
So how do you have demolition pictures on July 1st of a property that was finally demolished on July 2nd?
Because the inspector did his final inspection on July 1st when he took the pictures of the demolition being completed.
Okay.
He completes it in the system on July 2nd. So the actual inspection or documentation is loaded in the system on July 2nd.
Okay. So the final demolition was done on July 1st. What occurs during that final phase? Since you know about that, what happened in this case on that final phase? Can you tell me?
The demolition is completed. The area inspector fills out the paperwork and approves payment to the contractor.
Okay, so that's pretty much when the case is completed, correct?
Correct.
Okay, so if we said that we had pictures of this property already demolished and stuccoed prior to that, what would you say about that?
I would say that it might have been done prior to that, but the inspection didn't take place until July 1st. That's when the city officially closed the permit. Actually, the city completed and closed the permit July 2nd. So anything before that, that's on the contractor. But as far as the department is concerned, it is officially closed July 2nd of 2019.
Do you personally review the paperwork from the demolition contractor?
No, actually, our fiscal unit reviews that documentation.
I'm sorry, who?
Our fiscal unit.
Your fiscal unit.
Yes.
Okay, and then it's passed on to you.
Yes.
So you have no idea if that paperwork is correct.
I'm going to object to the characterization of that.
Actually, I know that for the bid process, whatever the numbers were that were awarded that day, then they're recorded into the database.
Okay, and how about follow-up work charges, anything like that? Are you aware of those?
Depending upon if there are additional work that are required for this property. This property required stuccoing the adjoining properties and also a sealing of the lateral, which is required on the demolition.
Understood. Okay, so if you know, can you tell me the entire amount of time that it took to demolish this property?
The demo contractor has 30 days. The demolition was completed on July 2nd of 2019.
And he has 30 days to do that for an imminently dangerous property. I got you. Okay. All right. No further questions.
Okay. Do any board members have questions at this point?
Not for Mr. Rabowski. I do not.
I'm sorry, what?
I don't at this point for Mr. Rabowski.
Oh, okay, I'm sorry. Any other
No,
board members?
No, I will await the city's direct of this witness.
Very good.
I don't have any questions. George, did you?
No, I don't have any questions.
Okay, so let's turn to the city for their presentation.
Just
I have my witness.
Oh, I'm
Well, hold
sorry.
on.
I
Yeah,
thought you
yeah.
were, I thought with what you said that you were finished with what you were
With this
presenting to the
gentleman,
board.
Yes, yes.
Okay, my apologies. I misinterpreted what you said. Please wrap up with your witness.
Hold on, I have a question. Does the city at this time want to do your direct of this witness? Because he called Mr. Rabkowski as a hostile witness?
If the board permits and Mr. DiNatale has no objection, I will reserve my questions and just present Mr. Ribikowski as on direct. I think that will make it more straightforward.
Okay.
I have no objection as long as I could follow up on those questions if needed. Thank you. I'd like to call my witness. Please state your name, sir.
My name is Omri Shitri.
I
Okay.
can hardly hear you, so you be sure to speak up.
Yeah, I can't hear as well.
Can everyone hear?
Repeat your name.
Omri Shitri. It's O-M-R-I-S-H-I-T as in Tom R-I-T.
Okay, it's borderline for me. I don't know about for the others, so just try to speak up when you're
Very
answering questions.
difficult to hear.
Sorry.
All right, sir, I want to draw your attention to on or about May of 2019. Can you tell me how you were employed at that time?
I was a project manager for GNR Construction that is part of GNR Group that own Philadelphia Lotus 6.
Can you speak more directly into the mic?
Yes, I was project manager for the construction team for a company that her name is GNR Group that is the owner of Philadelphia Lotus 6.
Okay, and are you still employed?
Yes,
Okay, in the same fashion or function or differently?
a little bit differently, but in the
Okay,
same fact.
but you have knowledge of what occurred on that time and date?
Yes,
Okay, and through July of 2019?
yes.
Okay, so let me draw your attention back to that time, and please tell the panel what, if anything, occurred.
You want me to tell my story?
Tell your story. The truth doesn't need any prompting or rehearsal. Tell your story. If you
So-
go off base, I'll stop you and redirect you. Go ahead.
Okay, so we are buying multiple properties that most of them is make safe properties. That's mean that these properties they are in a dangerous case. I'm dealing with Mr. Thomas on a daily basis. And I did hundreds of immediately dangerous cases in city of Philadelphia. Because we are buying properties in the sheriff tax sales, we know that the city take a long time to record the deeds. So one of my employees, that his name is Zach, is going to meet Mr. Thomas at the 11th floor at the LNI and bring him every week the list of the properties with the immediate that we bought. We don't know if they have immediately danger. We don't know what is the cases. And Mr. Thomas hand for him the violations. And by the violations that Thomas hand him, I start to correct the cases in order to fix these properties and to rehab. On this case, the property was on the list of the demolition. And it's already been assigned to a contractor. Mr. Thomas handed the violation to my guy and tell us that he's gonna hold the violation for 7 days. And he will give us the ability to fix this matter.
Okay, let me just stop you right there.
Okay.
All right, just want to make sure I heard you correctly. So you have an ongoing relationship with Mr. Thomas, and you specifically deal with Mr. Thomas with unsafe properties. Is that correct?
Yes,
Okay. You purchase properties at sheriff's sale,
yes,
and knowing that some of these may need repairs, you proactively go to Mr. Thomas and say, hey, this is what we bought. Tell us if anything needs immediate attention. Is that correct?
yes.
All right, continue.
We receive, I think during these days have some holidays in the middle, but I don't remember what is exactly the holiday. But we received this 7 days to to address the issue. My guy, that is the same guy, his name is Zach, went down to LNI with the engineer report that the engineer visited the property. My guy made a typo mistake and wrote the application easy, but next to the easy application, he write make safe as per engineer report. He got rejected because he cannot even talk with anyone because it's just the girl in the front desk type his application. And when she got to the progress that she need to verify the ownership, he didn't have the right documents on his hand. So they kick him out from.
Okay, so let me stop you there, just so we're all on the same page. So if I understand you correctly, did he go back to LNI for this make safe report?
Yes.
Who typed it up?
The front, I don't know, I'm not sure, but I'm assuming that the front desk in the LNI side.
Okay, and then is it your testimony she inserted a typo?
Or might my guy put a typo on that?
We don't know.
So I'm gonna object. He has basically said he doesn't know. So,
Okay, that's fine. After that now, is it true that it got rejected because they couldn't verify ownership? Is that it, or correct me? Tell your story.
That's what Zach came back to our office and tell us they cannot take the application because we don't have recorded.
I'm sorry, this is corporate. I can't hear you, sir.
So my guy Zach came back to the office and tell me that he cannot receive this. The city cannot take this application because we are not the owner yet.
and I am just gonna object for hearsay for the record and motion to strike again for the record.
Is there a ruling on that?
Nancy, you're on mute. Dominique, Paula, anybody else can help?
Sure. The motion to strike, which testimony specifically are you referring to, counsel?
The testimony that he was told by his guys, by Zach, that would be hearsay.
Okay, so we have noted it. When we are addressing or making an adjudication on this matter, we'll take that into note. It is noted for the record. This is recorded. We can proceed forward. Thank you.
Okay, now, if I understood you correctly, you first walked into LNI on the 22nd. You were proactive, you went in there. When was this permit filed or attempted to be filed?
On that day. I will tell you even more than that.
Hold on the 22nd this happened?
Yes.
Okay, tell your story, please.
So because we notified by Mr. Richard that we have a make safe violation, there is no reason for us to go and to submit for easy permit. Because we are doing this daily basis. We are not submitting something that is a minor alterations for emergency case. We are doing more than 200 properties like that. There is no reason for us to come to lie to the city.
Okay, all right, so on the 22nd, your permit was rejected. What happened next? So that's the 22nd, all right? We know the property got demolished the day of the TRO, which is June 5th. What happened in between? You get rejected. Did you make any other attempts? What happened?
I think Zach came back to the city.
Okay. And what happened?
Let me just memorize.
Okay.
I'm not sure about
All right,
it.
if you don't remember, you
I'm
don't
not
remember. Let's move forward. At some point, you retain an attorney for a TRO, as we've heard, based on a recommendation from somebody you were dealing with at the city?
Yeah, that's the day that I went to the city. It was on the 7th. And
Okay.
I met Thomas personally because I understand that they have an issue that the city don't let me pull this permit because I'm not the owner.
Okay,
So on the 7th, that was a holiday before that, I think, and that was the first day that was available to go.
okay,
I met Mr. Thomas personally.
I'm just
sorry?
gonna object. Can we just clarify the date? He just said the 7th. I just want to clarify that's June 7th.
Can you tell us the date?
Yeah, June 7th,
June 7th,
the
what?
day of the TRO,
What year?
2018.
You sure it's 18?
Not 18, 19, no?
I'm asking you.
19,
You're,
2018.
okay, very good. All right. Now, did you get an engineer's report?
Yes,
Okay, I'd like to show you Petitioner's Exhibit 1. I believe everybody has it. If they don't, could you please tell me? Okay, there you go. Take a look at that. What is it?
it's the inspection that I made with the engineer on the site.
On the site. You were present.
On this inspection, yes, on
Okay.
June 3rd.
What's the conclusion of that report?
The conclusion of this report that this property from visual report is not look like immediately danger. And the engineer is referenced over here to a cleanup in order for him to visit inside the property to give his full examination and in order to submit the plans.
And what's the date of that report?
June 3rd, 2019.
Okay,
And again, just for the record, I am objecting to any testimony regarding this. This is not a hearing about the determination of whether this property is ID. It is a determination of whether this bill was submitted appropriately. So I would object to all this testimony, but it's just an ongoing objection. Thank you.
and that's June 3rd. Did that report go to anybody in the city?
That's with this application that Zach submitted in the city, that came part of the application with the
Okay.
photos.
With the photos, and there's also a photo attached, so I want to show you that photo. Can you take a look at it, please? It's all part of Exhibit 1. And does that photo accurately depict the property in question?
Yes. this is
Okay.
the front of 1942, 46 now.
Okay, very good. Thank you. You mentioned you filed a TRO, is that correct?
Yes.
All right, I want to show you what's been marked as Petitioner's Exhibit 2. Take a look at it. Okay, you recognize that?
Yes, I know this. I did.
Okay. Well, let me stop you right there. Did you do it, or were you with somebody who did it?
I
Please
was
tell me.
with the lawyer that we did it in the city.
So you were with the lawyer that day?
Yes.
Okay, tell me about the TRO. So it was obviously filed. Was it filed? I'm asking you.
Yeah, it was filed.
You're pointing, what are you pointing to?
It's the stamp over here.
The stamp showing it was filed. Okay. Is there a reason it was never served on the city?
It's never served on the city because at noontime, that's all started at 9 a.m. when the city is open, and at noontime, the property is already been demolished.
And how did you find that out?
I sent my site visitor to go to take a look on the property, and he sent me a photo that the property has demolished and they already worked on the stucco on the site.
Okay, so that property was completely demolished on that day.
Yes.
Okay, all right. Let me show you, and this is what I sent today, and I intend to mark as Exhibit 4. Please take a look at this,
Yes.
all right? And this is what I'm looking at today's exhibit. All right, there you go. Take a look at it. What is that?
So that's my WhatsApp application. That's a text messages that I told my one of the girls that work with us, her name is Angelique, to send the site manager to visit the property. And I received from him a message at noontime that per his photos, the property has been demolished.
And
Okay,
just again, I'm objecting to the submission for lack of authenticity and hearsay.
okay, so hold on, let's get to this. This is, I'm looking at page 1. What is that? Is that a text message?
This is a text message
Okay, where'd you get that from?
from Angelique Gotts.
Was it given to you
Yes,
on your phone?
yes,
Okay, you have your phone with you.
yes.
Can you show me?
This one?
Yeah, they're questioning the authenticity of it.
At this point, the objection has been noted from the city. Can we move forward? If city decides to cross on this issue, we can go back and address if it's in the
Okay, you
zone
have
or
it?
not. But
Yeah.
let's keep
Well,
moving.
since we have it. right
I
here.
understand,
I'm
counsel,
very-
but at this
I
point,
understand.
your witness has testified to multiple other people that could potentially have been here today in order to testify firsthand. So we're trying to give the benefit of the doubt. So yes, proceed forward. Thank you.
And page 2, okay, take a look at that. Is that part of what's on your phone as well?
Yes.
Okay, what's the date on that?
So that's June 18, 2019. This is a program that is a project management program that anything that you upload to this program is automatically recorded by the time that you're doing it. So I have a timestamp for anything that anyone's doing.
Okay, is there a picture attached there?
Yes,
Okay, and what is that picture of?
this is a picture of the demo crew completing the stucco, the cement work on the sides of the building.
Okay, and look at the 3rd page. Is that a blow up of that picture?
Yeah,
That's the picture of the property being stuccoed on June 18th.
yes.
Okay. Let me ask you this. Is there anything else you could have done to try to stop this from happening?
That showed up a notice? No.
And that short of a notice, no. Okay. I have no further questions.
Sorry, just Albergan Cross. Sir, did you attend the sheriff's sale? Did you attend physically the sheriff's sale to purchase this property?
No,
Did a representative of yours do that?
yes.
When was that?
We have the dates over here. I don't remember exactly the date. It was March something, March 21st, 2018. I think.
And when you say you have the dates over there, what are you referring to?
You have dates here or is somewhere else?
No, I have my chronology.
No dates here.
Not there.
I'm sorry, sir, I can't understand. Can you repeat your answer?
I don't have the dates in front of me.
The dates are not in front of you on a table perhaps that you are looking at?
Oh, but I can open that and it will be in front of you and I can tell you exactly the dates. So if you
Okay,
want-
so you do have notes, but you're not referring to them. All
Right.
right. And those
But
notes,
it's not in front of my eyes, so I can't answer you from there.
okay, could you
One day I will
estimate?
put it.
Do you need to refer to your notes? Are they in your notes about when the sheriff's sale occurred?
Doesn't the city have that information? The
I'm just
date?
seeing if he knows.
We have no notes. As I
Okay.
said, he's
All right.
just going off his own testimony. The truth doesn't need a rehearsal.
About
Go ahead.
end of March.
Okay, so end of March approximately, the sheriff's sale.
Correct.
Have you been to a sheriff's sale before?
Yes,
And it's true that they announced imminently dangerous properties at the sheriff's sale, is that correct?
correct.
Okay. And this property, you would agree with me, the deed was recorded on May 12th, 2019?
The deed recorded.
Yes.
That's also something that you can agree, I disagree on that.
When would you say,
The deed was recorded and online to the system at the sheriff, June 8th, but it's got a different date.
you would agree with me that the deed reflects May 12th, 2019?
But I don't think it's the true, but the deed was.
Okay,
the deed
no,
was
thank you.
recorded.
I got you.
I will
Okay.
stipulate that the sheriff's acknowledgement is the 13th day of May.
Okay,
That's what it
On
is.
June 7th, we was in the sheriff department for the recorded deed, and the sheriff told us that he don't have the copy of the recorded deed.
okay. And when you went to L&I on the 20, or your person went to the L&I on the 22nd, you agree you were given, did you say a 7-day hold or a 10-day hold?
7 days,
Okay, and you knew you had 7 days to obtain a demo permit, correct?
correct.
Okay, and when you went back or I'm sorry, I say you, I mean, your associate went back to obtain the demo permit.
I just want to say something before that. I don't need to obtain demo permit. I need to correct the issues. There no one require us to pull a demo permit. And a
Fair
demo
enough. Okay,
permit
so they
should
asked
be
you-
more than 30 days. Hold
Okay,
on.
Okay, I'll go ahead.
so to clarify, you were instructed to either remedy the issues or you would have to demo it. You understood that. You would agree with that.
Yes,
Okay. And when your associate went back to L&I to obtain the permit to do so, you indicated that was rejected, correct?
yes.
Okay. Why didn't you bring something back to correct it at that point?
I think Zach, my guy, I don't want to testify instead of him, but he went back to the L&I department, but I don't remember what exactly happened, so I don't want to testify about something that I'm not sure.
But regardless, he wasn't successful.
Not successful.
Okay. All right, I don't have anything for this witness.
Just briefly on 3 points that were made. The solicitor mentioned that they announced dangerous conditions of a property at sale,
Yes.
right? Okay. Was it your testimony in this case that that's irrelevant because you guys go there after every sale and show the city your list to make sure there are no issues?
Yeah, because they not announced. It's one in 1,000 that they announced.
Okay, so you were proactive and you brought the list as you testified on direct, is that correct?
Yes.
Okay. Also, there's some question about the deed being recorded and why you didn't have it. Do you know when the deed was recorded?
When?
When? If you don't know, you don't know. That's fine.
I don't remember, but I remember that it was before June 7th.
Okay. And also, just because the deed is recorded, does it mean it's viewable the minute it's recorded, or is there a delay? If
I'm
you
going to
know?
object. This is beyond the scope of this witness's knowledge.
You may know, he testified he does this all the time.
Usually when the deed is recorded, it takes a few days and you can have it in the system. But when we go to the sheriff can get the deeds much faster than what is coming online.
Okay. Third point, you answered something about you didn't have to pull a demo permit. Could you expand on that?
Yeah,
What were you talking about?
as from my knowledge, when you have immediately dangerous case, you allowed to address the issues in order to stop this violation and to build your house back.
Were you being allowed to do that in other properties?
Yes.
By whom? By the gentleman Thomas Robert Kowski?
Thomas is not reviewing the plans and he's not, at the end of the day, he's in this department, he's the inspector that's going to the field and that's what they're doing. But
Okay.
down in L&I, where you're applying for permit, they reviewing your application. And if your application is support, the violation that Thomas put on the line, because they see the photos, they see everything and you need to address it.
But in this case, this was different?
In this case, that was different. I couldn't get to even to the person to talk with him about the permit.
Okay. All right. I have no further questions.
Are we turning back to the city at this point? I've kind of
Actually,
lost track.
I have a few questions
Okay.
for the witness, but I'm gonna
All right,
let
thank
Paula
you.
go first because I think Paula probably caught some. No, go ahead, Paula. So let me ask you a quick question. Were you at the actual sheriff's sale?
For this property, no.
Mhm. So your representatives were the ones that attended the sheriff's sale.
Yes.
So you don't know if they actually called out if this property was imminent dangerous, correct?
No, I don't know.
Okay. So your representatives are the ones that met with Mr. Rabakowski, and that's where they received the notice that this property was imminent dangerous, correct?
Correct.
Okay. Walk me through this TRO situation. You said you got an attorney for that?
Yes.
Who was the attorney?
Her name is Victoria Ruby.
Okay. And you said that you filed this TRO and that you actually got it stamped, right?
Yes.
What date was the TRO filed?
On June 7th.
On June 7th. Now, the testimony we heard from Mr. Rabakowski, and I believe you corroborated, is that you had till June 5th in order to provide documentation. Is that correct?
Yes.
Okay. So June 5th, you didn't provide documentation. And this is the first time you talked with Mr. Rabakowski about this property, correct?
Correct.
That's when you were told about the TRO based on your testimony.
Yes.
not recommended, just you were told about it. We'll concede to that. Okay. You then got an attorney and had one filed by that Friday, June 7th.
Yes.
What is your testimony as to when this property was demolished?
Again?
When was the property demolished? You had testimony that it was not the date that Mr. Robakoski is representing to us. So what was your date for demolish on this property?
I know that in June 8th, the property was not there.
What date?
June 7th, the property was already been demolished. And maybe
So-
before.
Okay, so as of June 7th, you said the property was already demolished, which would be a Friday. I looked up the date already. It was June 5th was a Wednesday of 2019. June 7th was a Friday. Okay, so as of that Friday, you said the property was completely demolished.
Yes.
Okay, and that's when you filed your TRO, was also on that date.
Yes, I think the weekend before it's a holiday. When my guy came there, and I don't remember what is this holiday, but it was a long weekend.
It would be Memorial Day weekend, would have been the
Memorial
following
Day
weekend, based on the timing of this,
Yes.
yeah.
So I could not get any engineer to come in Memorial Day weekend to come to give me engineer report in the property in that short notice. So he came on the 3rd.
Okay, so your engineer came on June 3rd though,
Yes,
and that's 2 days before you had the deadline of June 5th.
correct.
Okay, no further questions, thank you.
Paula, did you have questions?
I'm just going to piggyback on Dominique, but the photos that you provided of the property being as it's demolished, and I'm looking at it on the screen, I apologize, with the stucco is June 18th, not June 8th, correct?
So,
That you had a text on your phone, you said, and there was a picture there?
yes,
So that's, she's referring to my petitioner's exhibit 4
Yes.
in this picture.
June
And that's
18th.
dated June 18th.
Yes.
So how do you know that as of June 7th or June 8th, the property was demolished based on your testimony?
So all my dates is mixed? No.
Pardon me?
You testified that on June 7th, the property
Yeah, the
was already
property
gone.
was
The
gone.
question is, how do you know that?
My guy went there, but he didn't took photos. He said that the guy is there and they
So
demolished.
somebody actually went to the site.
Yeah, and I
And
have
look.
it on a phone call and I don't have record.
Okay, thank you. I don't have anything else.
Okay. Well, I guess unless anyone else has a question that from the board's end, we should be turning to the city for any additional material that hasn't already been covered.
I understand. And just
I would
very
ask that
briefly,
all
for-
my exhibits be marked and moved into evidence at this point, please.
That's understood.
Rest our case.
Yes.
and there's our standing objection to those exhibits. Okay. I will present Mr. Rebekowski. Mr. Rebekowski, you still with us?
Yes.
Thank you, Mr. Rebekowski. And can you just, I think you've testified multiple times, but can you give your background with the department?
So I'm a
Really not
supervisor.
necessary,
I'll
Mr.
stipulate. I know him well. Not a
Okay.
problem.
Thank you, thank you. Mr. Rebekowski, I'm gonna share my screen so we can all see the exhibits as we move through. That's everybody. Mr. Rebekowski, can you see what's on my screen?
Yes.
Hold on, let me fix this. My apologies. Okay, I'm gonna scroll up to what's been marked as City Exhibit 1. This is the deed. Do you see
I'm
the
sorry,
date?
it's actually City Exhibit A.
Oh, that is how the alphabet works. Thank you, Mr. DiNatale.
A 1's not A.
No, hey, I love a helper. Mr. DiNatale, do you see, or I'm sorry, Mr. Rebekowski, do you see the date on this document? Right here.
Yes,
Okay. And that's May 13th, 2019. Is that correct?
correct.
Okay. And can you tell the board typically how sales at how sales of imminently dangerous properties happen at sheriff sales?
So for properties that are being sold at sheriff sale, the sale is the address of the property is read out. They take a bid process. The winning bid or the winning buyer of the property has a certain amount of time frame, or makes a deposit and has a certain amount of time frame to follow through with the rest of their settlement cost, and then the property is awarded to that owner.
And if a property is imminently dangerous, is that made as a notation made at sheriff's sales?
I'm not really sure. I have heard that through other hearings and representation, but I've never actually heard them say it.
Okay. And to identify the property addresses for any individual premise, does L&I use OPA to identify those addresses?
Yes, so our system, which is now Eclipse, but for this property, it was the Hanson system. L&I draws its property ownership records by the OPA, which is the Office of Property Assessment.
Okay, and OPA in this case reflects the property as 829 North 29th. That's shown on government exhibit B.
It represents this property as 1946 North Napa, and it has the mailing address of 829 North 29th Street.
Okay. And scrolling down to City Exhibit C, do you recognize this document?
Yes,
What is this?
this would be a copy of the notice of violation indicating the property at 1946 North Napa Street is being declared as eminently dangerous. The date on this notice is 5/21/19, which would be when this property was declared as eminently dangerous by the department following one of the inspections that took place. This is
Okay,
also a copy of a notice of violation that I printed out and handed to the representative that came to the floor at the time the property was placed to bid. I believe his name was Zach.
okay. And these notices, this describes the violations that the property has, is that correct?
Yes,
Okay, and it likewise provides any opportunity for questions if there are those about the violation,
correct,
and an opportunity to appeal this violation, correct?
correct.
Okay. And scrolling down, what is this?
This is a green card. This is a notification that we sent a certified letter to the owner record. In this case, this is a certified green card coming back that the demo bill for this property had been delivered to the recorded address.
Got it. So
I
this
know-
refers, oh, I'm sorry, go ahead.
I know that because it references the case number, which is 683613, which is the same case number that's on that notice of violation. But in the corner, there is a handwritten demo, which reflects that this is for the demolition bill.
And that's to ensure that the demolition bill is actually received by the petitioner, correct?
Yes,
Okay. Being down to City Exhibit E, do you recognize this photo?
this is a photograph of the front of the property at 1946 North Napa Street.
Okay, and specifically, what is this orange notice on the building?
The orange notice is actually, there's two notices on that door. One is no trespassing sign. And there is a notice posted under that, and that posting is a eminently dangerous posting that the department posted on May 7th of 2019.
Okay, and
I'm
that,
sorry, did he take these pictures? I didn't hear that part, because he's testifying to what these are. I don't see any addresses. I just want to make sure he took these pictures, please.
I did not take these pictures. These pictures were taken by the area inspector at the time the property was placed as eminently dangerous.
and, okay, and that notation, you said that's 5/7, that's the date up there?
5/7/2019, yes.
Okay, and scrolling down, is this a close-up of that? Oops.
Yes. So that is actually a close-up post or picture of the posting of the front of the property at 1946.
I object at this point. I'm going to object to this. It's a close-up of a picture. There's no property anywhere in sight. It speaks for itself. I'll give it that it's certainly a notice. We don't know where that notice was, where it was posted, if it was posted. And he didn't take these pictures. So I object.
Your objection has been noted. You can proceed forward with your case in chief. Thank you.
I know, I'm just gonna back up. Mr. Rebekowski, when you prepare for these hearings, do you review L&I's records?
Yes,
And when inspectors go out, it's such as in this specific case, what is their normal course of procedure?
They observe the violations of the property, whether it's being declared as eminently dangerous or unsafe. And then while they're doing their inspection, they will post the property accordingly, whether it be unsafe or eminently dangerous.
Okay, and do they take pictures?
Yes,
And when they get back to the office, what do they do with this information?
those pictures are uploaded to the database. This system and the case record is added to the Hanson system in this case. And the pictures are uploaded to a hard drive system that L&I keeps in an ordinary database.
And how soon do they do that after, when they get back to the office? How soon from being in the field to when they get back, do they upload these pictures and notes?
So each inspector is different, but most likely this would have happened the day after the inspections.
So it's the practice that it's done within a day.
I'm sorry, I'll
Yeah.
stipulate to this, you really need whatever, business records person here, but that's fine. We know it's the property. I'm going to stipulate to this, but I will not stipulate to that being on the property, which is the former notice, because it's not on the property. It's just a picture of a notice, but the
We noted
pictures
it
are
for the
fine.
record.
Please
We noted
continue.
it for the record, let us move on.
And Mr. Rebecca, so I just asked that we will be asking that those be admitted as business records, but thank you. Moving on to Government Exhibit F, do you recognize this document?
Yes,
And what is it?
this is a case description for the property at 1946 North Napa Street. It declares the property as eminently dangerous. It references the case. It references the property, and it basically spells out the case written against this property.
Okay, and does this include notations about the case, other information?
Yes,
Okay, I'm gonna scroll down 1, 2. Scrolling down to the 5th page of this document, does this contain, can you read this notation?
yes.
Go ahead.
So for that notation, it says new owner came, or it reads, new owner came to the 11th floor on 5/22/19. Demo has been placed on hold for 10 days in order for owner to apply for a demolition permit. If demolition permit is not applied for, city will remove hold on 6/5/2019. Copy of NOV, which stands for notice of violation, given to owner, uploaded to an OLE, which is another database or a internal record in this system.
And
So
that
image of that notice.
And that corresponds with your recollection of what occurred in this case, correct?
Yeah, I'm the one who put the note in. My number 261183 is just above that next to the date.
Okay, and scrolling down to City Exhibit G, do you recognize this?
Yes,
Okay, and this confirms that you did in fact place the hold on this demolition, is that
yes,
correct?
yes. This is an email that I sent to the representing demolition contractor who won that bid, and that is A&M Curran. I sent the email following the conversation that I had with the owner representation that we were placing that demolition on hold. That email was sent May 22nd, 2019, basically placing that demolition on hold.
Okay, and that's the same day that the representative came to L&I.
Correct.
Okay, moving on to H, oops, sorry. You recognize this?
Yes.
What are we looking at here?
We're looking at photos of the property that I took on June 7th of 2019 in anticipation of a TRO filing. The demolition has started in that the fencing is in place. The contractor was on location, but hadn't started the demolition. Accordingly, they were getting ready to start the demolition. As we did not have anything filed, they were continuing with the removal and also the demolition. You can also see the neighboring property was occupied in that the occupant is standing on the front steps.
Okay, and moving down, this is another photo, correct? Sorry.
Yes.
Okay. Moving down, do you recognize this?
Yes.
Same property?
Same property. This is another photograph of the property on 6/7/19.
Okay, moving down, what are we looking at here?
This is a photograph of the interior of the property. All the structural members are essentially in the basement of this property. If a permit would have been issued for this property, it would have been a demolition permit, because under Philadelphia code, If more than 2/3 of the structural members of the subject property and a piece of the exterior building envelope needs to be replaced, it constitutes as demolition and new construction.
Okay.
The shoulder.
Sorry, I couldn't tell.
Oh, go ahead.
And so when you say the supporting structures, how much of this house are we looking at? What are right now?
Right now, you're looking from the front entryway of this door or the easement. And there is several structural members that have collapsed or in a state of collapse. The roof is pretty much non-existent. And there is several structural members or the pieces or remnants of that is in that photograph.
Okay, and structural members are floors, stairs, things of that nature?
Structural members are the floor joists, the roof rafters, anything that would be structural.
Okay, moving down. What are we looking at here?
Another photograph of the interior of the property shows that the roof itself is collapsed, plus the second floor flooring assemblies are in a state of collapse or not existent. Also shows the first floor also has issues as well.
Okay, and there's essentially no roof visible at in this picture, is that correct?
Correct.
Okay. Moving down here, what are we looking at here?
It's another photograph of the interior of the property.
Okay, and here.
Another photograph taken for the second and roof assemblies of the property.
Okay. Same with this.
Same photograph.
Anything additional?
No.
Okay. And again,
This shows the state of the rear of the property. It's actually the rear wall, as this would be a breezeway. So it shows the rear exterior wall.
okay. And here,
This is the rear of the property.
okay. All right, so now we're going to move on just to the bid process. Can you just briefly outline for the record how the bid process works?
Typically, when a property is placed to bid by the city, we have multiple contractors go out to the location. They survey the site. They come up with their price. They submit it into the department. The department takes the lowest bid. In this case, we received 5 bids for this property.
Okay, and so this is what we're looking at, City Exhibit 1. Can you just explain what that is?
This is a copy of the PHL contracts from our fiscal or procurement department. This is for the bid for the subject property at 1946 North Napa Street. We received 5 bids for this demolition. The demolition was awarded to A&M Curran for $13,735.
Okay. And this document here, what does this reflect?
This is the invoice that the city received for the demolition from A&M Curran LLC, which is the award-winning demolition contractor. They charged the taxpayer $13,735 for the demolition of this property.
Okay. Moving down to, that's now marked Government Exhibit J. What does this reflect?
This reflects a photograph that was taken July 1st of 2019 when the area inspector finalized the demolition permit and basically approved payment for this demolition.
And how does that work? Once a demo is completed, what does L&I do?
L&I, the area inspector, will fill out the procurement paperwork, approving payment. It is sent over to our fiscal unit. The fiscal unit goes through what it does and basically approves payment going to the contractor for the demolition. In this case, this was done July 1st and then completed in our system July 2nd.
So L&I has to go out and confirm that the demolition is complete, correct?
Yes.
Okay. And moving on to this document, what document is this?
This document is the interior or the interdepartment approval that this demolition was completed. This document was actually filled out July 3rd, 2019, and it was completed by the inspector.
Okay, and why are the dates different on these two documents?
The dates are different in that the permit is the final picture is taken, then they come in, they do their notes. They complete it in the permit process, and then they go and they fill this out. They might do this all in one day. It might be the day after, just to get multiple. They might have multiple payout slips. This is called a payout slip. They might have multiple payout slips they have to fill out that day. So they like to do it all in one shot, or at least that's their time management.
Okay. And moving on to this document, do you recognize this?
Yes.
And what is this?
This is the invoice that the department received from A&M Curran for the demolition at the property. It indicates that the inspections took place. It also indicates that the property or that the winning bid price was $13,735.
Okay. And lastly, what is this?
This is another document for A&M Current. It basically just represents the same thing, but it also spells out the purchase order, which is the financial document from the procurement department to proceed with this demolition.
And this also certifies that all the materials that are used are safe for the public.
Correct.
Okay. Lastly, moving on to City Exhibit K, what is this document?
This is the bill that is generated by L&I that we send out to the recorded owner. It is for the demolition. This price is $16,619.35. It is including the original price of that $13,000 plus the 21% administrative fee.
Okay. Now, I do just want to reference this because this came up before. When contracts are awarded to contractors, they can begin that contract any day that contract has been, once that contract has been awarded. Is that correct?
Once a property is awarded to the demolition contractor under the master demolition program, the contractor can start the demolition within 3 hours of winning that bid. They can complete the demolition within 30 days. So essentially they have 30 days to complete that demolition. When they start is up to them, as long as the property is fenced off or, but they assume the responsibility as they are the winning bid.
Okay. And L&I does not monitor when they start.
We have a demolition permit that is issued. We inspect the progress as the demolition goes on, but when they start that, that's up to the demolition contractor.
Okay. I'm going to show you, oops, for indulgence. I believe this was marked as Petitioner's Exhibit 1. This is a copy of the engineer's report.
Yes.
Do you find this a credible report as a CSU supervising inspector?
No.
What are the issues you see?
He's not an engineer, unless I'm maybe he is. Are you, sir?
Not reviewing any plans.
I missed that. I'm so sorry.
I'm sorry, I'm objecting because he's not qualified. He's not an engineer and he doesn't have the plans in front of him to make that determination. How can you do that by reading a report, whether it's credible?
Why he didn't give me the permit?
I'm not sure if I can answer that question or what question am I answering?
He can testify as to the city's use of that report as it would have been handed over to him.
If this report was handed to permit services downstairs for a permit being issued, it would be rejected outright. There is no description on repairing this property. There is no description on demolition. There is no description on the means and method or at all on how to repair this property. It basically just says that the interior of the property needs to be cleared out. The front wall, that's all they looked at, and that's about it. They observed it from the front, from the street.
Okay. And last thing I'm going to point out, and I believe this was in Petitioner's Exhibit 2. Do you recognize this document?
Yes.
And what is this?
This is an application for a permit for this property. And it just says that this permit was applied for on June 5th of 2019. And it says permit application rejected by, I'm not sure whose handwriting that is.
Sure. And with this permit, is this the easy permit you were referring to previously?
If I could refer, I could, that permit number 983028, if you would permit me to look at the permit notations, I would be able to tell you.
Sure.
Okay, so I have the same permit number as 983028. But this was filled out as a permit application, and there is a date on there as 6/7/19, which matches the notations I have in the system as application rejected from 6/7/2019, application rejected. Property is approved for curbside demolition already, cannot process. And
Okay.
that coincides with the original statements through today's testimony.
Okay, anything additional? Is this permit appropriate for the kind of work that would have been needed on that property?
No,
And is this, okay, all right, I have nothing further.
I have a question on something that showed up as you were going through those documents. In a demolition bill that comes from a contractor, do they submit that bill to the city on the date that the contract is awarded, or do they do it later? Because I saw on two of the forms a 6/4/19 date on the contractor's bill. And I just wanted to get an explanation on how that works.
that could be their own internal, that could be the contractor's own internal office putting that date on there. I wish that they would send in their contracts, their invoices.
It's back a few more pages from what's on the screen. There's one of them. Oh, no, excuse me, though, that's not it. My apologies, that's not it. It's back further.
Tell me when to stop, Chair.
They were bills from the contractor.
That's these.
That says final inspection done on 6/14. No,
This one?
it was a bill from the contractor directed to Ellen and I.
Yeah, that's this document.
Is that,
Yeah.
okay, that one does say invoice for complete demolition, and it has a 6/14 date on it. And that's why I was just wondering, because you were talking about the work being completed later than that, and that's why I was wondering.
I don't know why that June 14th date is there. That could be an error by their
I don't, there
billing
were
department.
there were two different ones that had that same date on it. That's why I noted it. And I didn't know whether that was a normal practice or if it was something that was an anomaly here.
You know, Nancy, now that I'm looking at that more thoroughly, and maybe Mr. Rubikowski can speak to this, it says final inspection done June 14th.
Right,
But I also note that the date on the document is June 14th as well. So I don't know if that's an internal error by that clerk or by that office staff from A&M Curran, but I know for a fact that this demolition was approved and signed off by the department for payment on July 3rd of 2019.
there was one other form that was a bill that also had the 14th on it. So the 14th of June, excuse me.
Mr. Rubikowski, were there separate inspections for the demolition and then the stucco?
Yes, so we
Okay,
have.
that might be it then.
Under this, under the demolition permit, there are multiple inspections that need to be done by the area
Okay.
inspector.
Okay, that would help to explain it if that would be the case. I just wanted to call attention to it because it seemed out of line with what you were saying about it, and yet it was in the review process. Anything else, Ms. Day?
Oh, go ahead.
Ms. Curley,
Is
is
that-
that your case?
Yes, I'm sorry, nothing further.
I
Thank you.
actually had a question for Mr. Rubikowski. Sorry, butchered your last name. Apologies.
That's fine, I'm used to it.
You said that the permit that was submitted on June 5th was rejected because the demolition had already started, or was it rejected because it was not the appropriate permit?
Well, actually, if we go back to that permit, it says in here that the permit was rejected because the property was already placed to demolition, cannot process the permit. And that was on June 7th. But knowing that this permit was entered as an easy alteration permit, this is the wrong permit anyway, because an easy alteration permit is just that. It is an easy permit. It is basically an over-the-counter permit, which describes no structural repairs to a property. As you can see from the photos, this property needed an extensive structural repair.
I understand that, but the permit was submitted on June 5th, right?
No. So if Miss Carly would go back to the, that permit application.
Mhm.
So I have that, there's some inconsistencies in this application, in that the font, it's a typed document with clean out property, remove debris, but no structural or load-bearing walls, so engineer can enter and assess the property. Somebody typed that in, and then they went ahead and they entered the notation on 6/7/2019 that the permit application rejected by L&I. It's scribbled, but it's rejected by L&I. And then somebody goes ahead and signs the report on 6/5. So in my notations in the system, the notes on this reflect the 6/7 date. They don't reflect the 6/5 date. And at that time, there was no permit in our system on 6/5. On 6/7, there was a permit that appeared 6/7, 2 days after the approval to start the demolition was given.
Okay, so your testimony is that this permit was not filed on 6/5. It was actually filed on 6/7.
My testimony, according to L&I's records, the only thing I have in here is from 6/7/2019. I do not show any recording or any information that this permit was filed on 6/5.
Okay, thank you.
You're welcome.
May I?
Were there any other questions from board members before we turn?
No, not from me. I would say,
No, okay.
Sally, do you have a quick wrap up?
Yeah, I was just gonna say, is there something else that hasn't been covered that we can deal with as a part of a wrap up?
Well, there's a couple things I want to touch upon that he testified to, which I said I wouldn't object to.
Okay, let's do it as quickly as we can, please.
Thank you. Sir, so speaking about that permit, you said it's an easy permit. Doesn't that permit address load-bearing walls?
No, it says no structural repairs on that permit application.
So it says nothing about load-bearing walls.
No, it does not.
Okay, the permit will speak for itself. Also, is there a reason why there's not a date stamp on that permit?
I don't know.
Okay, so is the procedure to date stamp those permits?
No, I'm not aware of them date stamping the permits when they get into L&I for review.
So are they applied for, maybe placed on somebody's desk and then entered into the system?
Objection, this is speculative.
The only notation I have is that a permit application was filed with the department on 6/7.
Okay. Okay. I want to go back briefly to what you testified about sheriff's sale. You were asked whether unsafe properties were called out at sheriff's sale. Are you familiar with the way sheriff sales work?
No,
You're not. Okay,
Oh.
so we shouldn't take into consideration anything you talked about during the sheriff sale?
no, I do know that in the process of a sheriff's sale, the potential buyer will open a bid, win that bid. They have a certain amount of money that they need to, a certain percentage that they have to put down. They have a certain time frame that they have to meet the rest of the payment, and then the property is awarded to that potential bidder.
And are you also aware about a right of redemption?
Yes,
What is that?
Mr. Natale, I don't see the relevance here for us.
Well, the relevance we'll put that together at the end in argument, but essentially, there's a right of redemption. And
I understand that, but your client's already testified that he went in and he already knew when he went in following his purchase, regardless of what happened at the sheriff's sale. So
Correct.
what happened at the sheriff's sale has no relevance in this arena.
Well, it was testified to that my client received service. In reality, as part of a normal business practice, he would go in after every month, after.
We
our-
understand that, so we can move on from there.
Okay, very good, very good.
7 days or 20,000.
What?
7 days from here or 20,000 bill. Choose.
Right, gotcha. Okay, that's all I have, thank you.
Okay. All right. I think unless there's something else that a board member has, we need to be stepping aside to see what we want to do with this matter.
Agreed.
Like to hear our argument?
And I would just ask that our exhibits be admitted. That's the only thing.
Okay, I thought we were finished, but go ahead if it's quick.
Yeah. So essentially here, the question was, what relevance does the right of redemption have? And I basically summed it up in my submission of exhibits at the end, the conclusion, what should be the outcome of this case and why. So what we have here is we have a client. The reality is they were never served. They, in their own business practice, happen to go into L&I every month. They're proactive. And they don't have to do this. They go in on their own volition to try to make things right, try to get things right. What happens here is when you purchase a property at sheriff's sale, there's a right of redemption. And under the case law that I've submitted, the case law will tell you that because there's a right of redemption, these folks have no responsibility to this property until that right of redemption is over. Specifically applying that theory to this case, these violations were not due to any conduct from my client. Okay, they were the prior owner who neglected the property. My client could have theoretically sat back and done nothing and said, hey, there's a right of redemption here. This isn't my problem. Or step B, which he was advised to do, is go back to the sheriff and rescind the sale. Well, he didn't do either one. Why? Because it's not the right thing to do. It's not the right thing to do for anybody, including the citizens of the city of Philadelphia. The right thing to do here was try to make things right. What happened is the property ends up being demolished because this occurs over a Memorial Day weekend. And in reality, from May 22nd to sometime before June 7th, we can figure out the days. It's pretty much a short time frame. The property gets demolished. Why should he fit the bill? That isn't equitable. The bill should go to my client because why? Because he bent over backwards, spending money and trying to do the right thing? No, he shouldn't get the bill. And that's our position here.
Okay, thank you very much. Did the city have a closing comment?
Just very briefly, the testimony was today that he purchased this property sometime in March at a sheriff's sale. He acquires all liabilities for this property in March. Case law is very clear on that. Additionally, he was provided yes, it was. He was provided.
Let the city make their statement.
Interrupt her.
That is not the case law. That is misstating the law.
I would really appreciate if counsel and his petitioner cannot interrupt the city. She was very mindful of your
I
time.
understand.
We have been here listening to both sides for 2 hours. At this time, please let her finish.
And I would just point the record to 168-839-225, which is a Commonwealth Court decision in 2017 that summarizes that law. Additionally, their testimony today was that this petitioner was provided actual notice, and that actual notice was documented in all the records we reflected today, and that the demolition occurred after the 5-day appeal period. There was no appeal to BBS in this matter, and this bill should stand. Thank you.
Okay, thank you. The board is going to step aside to consider what we want to do with this matter.
If everybody could just stay put, the board is going into a virtual room.
You're on mic.
I don't know where the petition is. Hold on.
Okay.
The board has reviewed things and reached a decision. I'm going to call on one of my fellow board members to outline what it is we're looking for, because we want to continue this matter for some additional information.
So first and foremost, thank you both for putting on your cases today. However, this did take in excess of approximately 2 hours. And sadly, petitioner did not put on their real argument as to what the issue is regarding payment until the end, regarding the redemption period, and pretty much how does that play into him actually being responsible for the bill. Because of that, we are going to take this under advisement, and we're asking for a letter briefing from both parties within 15 days outlining what is the redemption period according to Philadelphia County.
I'm sorry, you're breaking
Sorry,
up.
you're muffling, you're breaking up.
Is somebody touching a microphone or something? Is this like a ruffle in the back? Okay, go ahead.
Okay, so what is the redemption period in Philadelphia County, and what is the petitioner's obligations during that period as it pertains to this L&I demolition? We'd like that letter brief within 15 days, and upon receipt, we will be able to make an adjudication based on the pleadings, the briefs rather, excuse me.
Very good.
And it's already been established that I'm very bad at dates, so I just want to make sure that's the March 11th. That's what I have. 15
1
days.
second, I just want to make sure that that's March 11th.
Okay, unless there are further questions from the parties, we'll close this activity for today.
I concur with the decision.
Oh, yes, wait, we should put that on the record that the board members concur in what is being presented.
Paula Weiss, I concur.
And Nancy Cameradiner, I concur. And Dominique, you presented it, so I assume that you concur.
Yes.
Okay, thank you all very much. This portion of our hearing is adjourned. We do have some other items on our agenda, but thank you very much for coming in today, and we look forward to getting your communication.
Thank you very much for your time.
Okay, at this time, we have cases 4 and 5. They're actually in our office. However, I do want to address Ms. Peruto, who I think is still here.
I
She
know.
is on case number 3. That's the petitioner's attorney for case number 3. I just want to know, 4 and 5 was here before her. So I guess at this point, I just want to ask her how she wants to proceed, or does she want to wait, or?
So Ms. Peruto and I feel so bad. We were able to reach an agreement approximately an hour before this hearing. So poor thing has been waiting.
Well, thank you for your
That's the thing,
patience.
we didn't ask for anything like that, not expecting this one to go as long as it did. So
surprise.
It's fine. I was multitasking while I was waiting.
okay. If we could, first off, let's identify this one. It's which item on the agenda? Item
Number 3, Nancy.
Item 3, Philadelphia Suburban Development. Last
Yes.
4 digits of the docket, 8999. Please identify yourself for the record.
Lori Peruto?
Do you swear or
General
affirm to tell the
Counsel.
truth with everything that comes before the board?
Yes.
Okay, thank you. And this is a discussion in terms of an agreement between you and the city on this matter, is that correct?
Yes.
Okay. What is the position? And then we'll get confirmation from the city's end so we can determine what, if anything, we need to do.
Well, let me pull up the.
I can go ahead if that is helpful.
If you
Ms.
have
Peruto-
them.
Yeah, Ms. Peruto is counsel for Philadelphia.
Oh,
Suburban.
my apologies. I didn't realize she was counsel.
I was, yeah, General Counsel.
Okay, but my apologies. I thought, never mind. I didn't think you were legal counsel. Okay.
So the agreement will be to settle this matter, $22,100 payable, I think within 30 days. We're going to work out the timing exactly, but that seems about right. We will have that agreement to the board shortly. This was
So that basically we should be holding this under advisement for confirmation of the completion of the agreement. Is that
yes,
Yes.
and then once we
an
have
appropriate
that-
description?
correct.
Yes.
So we're gonna mark this as continued, and then once the settlement papers are done, if you could just send them over, or Ms. Peruto, if you could just put in the withdrawal papers, and then we'll get rid of this one on our docket.
This is actually a city appeal.
Oh, it's a city appeal. Oh, well then, that works out. Okay, so I'll look for your withdrawal papers.
Okay, great.
Okay, fine. Thank you very much for your patience with us while we dealt with the other matter, and we look forward to getting the concluding documents for your case.
Thank you. And Caroline, thank you very much. It was a pleasure working with you.
You too, Lori. Thank you so much.
Bye-bye.
Okay, thank you. Okay, then that takes us to items 4 and 5.
One second, Nancy. One
Five
second.
Brothers LLC.
Nancy, just one second.
Oh, okay.
I want to just bring up case number 2. You could put 4 and 5 in the room. Case number 2, I received an email from Mr. Michael on Thursday, February 24th, 2022 at 6:11 p.m. So it's a little weird because
That's a little impossible.
I don't know how he sent this from the future, but in his email, he notes, I'm writing to inform you that I need to schedule a continuance for this hearing due to being unable to attend today's hearing. I just realized that I have a root canal scheduled for the same time. Thank you for your understanding and consideration. If you have any questions or concerns, please feel free to contact me at any time after today. And he provided his phone number. But again, I received this email on Thursday, February 24th, 2022 at 6:11 p.m. That has not occurred yet.
Amazing. It's amazing.
I'm very, very confused by this. Perhaps he's in another time zone, I just don't understand. I do want to bring up the case file and note how many times this has been continued. I'm sorry, I'm just trying to find the file. Sorry, that was just surprising to me. This case was filed originally 6/5/19. There was a continuance on 9/17/19 by the petitioner. There was a decision by a master in 2020, November. There was another listing by the board April 8th of 2021. It was continued because the petitioner requested a continuance. At that time, however, the board noted no further continuances for either party. Please put that on the letter that was sent out to the petitioner. And sure enough, on the letter to the petitioner, it was advised that no further continuances would be granted for this matter.
I think we spoke on that already then, so I'm
Nice.
surprised it was even scheduled based on our decision from before.
No, we gave him one last continuance.
This
No
was
further
the last one.
continuances. Yeah.
My apologies, my apologies. I misunderstood what you said there.
Okay.
Just for the record, this is Michael Rulo, R-U-L-L-O, on behalf of the city of Philadelphia and this mayor. Just to confirm, the city would oppose a continuance in this matter. The one thing that I would just note, because I think it is important here, is that the petitioner is actually not the person that this bill was directed to, nor is he the owner of the property. So I think one of the things that may go into the decision there is he has no standing to prosecute this matter.
You hit something that I noted when I was looking at the documents we were provided before today's hearing and was interested in knowing more about how and why he felt that he was entitled to be appealing to this board.
But he isn't here to address that, so I
Exactly,
don't make a decision regarding that.
And I can just represent for the record that candidly, I went through this file pretty extensively and have been unable to find a connection between him and the property owner. The only thing I'd note is that it appears that he may reside at this property that the bill was sent to, which the actual owner listed as their property. But other than that, I leave it to.
One of the documents we were provided indicated that someone with that same last name was deceased, and the person who is now the owner of the property was representing the handling of that estate. So
we have the
maybe
deed.
something there.
Didn't you provide us with the deed that says?
I did.
There was a deed that had a previous property owner who was deceased, and the property
And he's the
person who became the
administrator.
property owner was handling the transfer of the estate, and he became the owner. So there may be a question about the
In any event.
But these are issues that can be
Yeah.
determined upon another hearing. So I think, we schedule it, we grant the continuance, no further continuance is granted, and then, or is this already the one that there was? no
This is already the one.
This
where
is
we said
already the
denied.
one.
It's
Yeah,
denied.
now that, yeah.
It's denied. That's,
Continuance request denied.
yeah, it's denied.
At that point, we're gonna mark this file denied, did not appear.
Yeah.
And I have the board concurrence on this matter.
I
Dominic
think-
Ward concurs.
Nancy Camerdiner concurs.
Paula Weiss concurs.
I don't believe George is here anymore. He said he had a hard stop.
Yeah, yep.
But we still have enough for,
Okay,
Okay.
leaving cases 4 and 5.
okay. These are for Five Brothers LLC, docket numbers ending in 6930 and 9284. Do we have representative from this property in the hearing room?
Yes, he's in the hearing room.
Yes, Madam Chair, Rosario Griffo on behalf of Five Brothers LLC.
And are you an attorney or are you?
I am.
Okay, I just didn't know whether I needed to swear you in or not. Who has this matter for the city?
Nakia Clark on behalf of the city of Philadelphia.
Okay, do you have anyone who will be testifying who needs to be sworn?
Yes, I believe Inspector Wade, who was already sworn, and also Inspector Rabakowski.
Okay, they've already been sworn. So if you use their testimony, then we can already go with the concurrence on the swearing in from before. Does the city have any initial opening comments and any numbers that we should have for the record?
Yes, so this case is in reference to a property located at 2040 West Glenwood Avenue, which was deemed eminently dangerous and subsequently demolished. The city of Philadelphia is seeking reimbursement for the total cost of the bill in its entirety, and the city will call Inspector Richard Wade for a reading of the bill at this time.
Okay, thank you. Mr. Wade.
Yes. This is for the property at 2040 West Glenwood. We'll read the first petition for the demolition. Bill date April 26, 2019. Bill amount, labor $17,200, an administrative charge $3,612. Interest to date $4,058.34. The total amount due $24,870.34. The second bill was for the sealing of the lateral. Approximate bill date April 4th, 2019. Labor $495. An administrative charge $103.95. Interest to date $107.64. Total amount due $706.59.
Okay, thank you. Does the city have any other opening comments or should we be turning to the petitioner?
You can turn to the petitioner at this time.
Okay, fine, thank you.
Madam Chair, before we begin, I have a couple of exhibits. Can I share those with you?
Yes, do you have access to the computer to do a timeshare on the screen or how were you planning to
I have
share?
paper copies. Are you?
Oh, paper copies.
Yeah.
Just a moment, someone will be.
I'm coming and I will scan them into the system for everyone. Hold tight, please.
Thank you. Sorry about that. So
Just
here,
let me know earlier, okay?
yeah, I just,
It's okay, okay.
so that's.
Have these documents been previously provided to the city?
What's that?
Have these documents been previously provided to council for the city?
They were provided from the city. And most of these are like public record and the things that I got from a right to know request.
So the answer is no.
No.
Okay.
I would request that you move a little closer to the computer if you can, so
Sure.
that you're close to that microphone. And that will help to improve our ability to hear what you have to say when you're actually making statements. Is there
Thank you,
anything you
Mom.
can start with while the copies are being put online for our access?
Oh, absolutely. I can get down to the point where I was going to use those copies and at that point we can, I guess, just take a break till I get them in your hands. Just again, for the record, Madam Chair, Rosario Griffo on behalf of Five Brothers LLC. Five Brothers LLC is the owner of the property at 2040 West Glenwood Avenue. And this appeal today stems from a September 30th, 2019 master's decision denying Five Brothers TRV petition for abatement of the demolition costs associated with the demolition of the structure situated on their property. At said hearing, city representatives, I believe, including Mr. Rybakowski, if I'm pronouncing his name correctly, testified, and I'm paraphrasing here, testified that any notice related to the property concerning either the citations or the demolitions would have been sent in the usual manner, but had no proof with them at that particular hearing that any notice was actually sent to petitioner. Any particular notice was sent to petitioner. Petitioner contends that it did not have the opportunity to cure any defects cited by the city prior to the demolition because it was not notified of the citations against it, assessed against its property prior to the impending demolition. By way of background, the city cited the property as unsafe on July 19th, 2018. It cited it eminently dangerous on August 1st, 2018, and the property was scheduled for demolition on or about September 14th, 2018, some 45 days after it had been cited as eminently dangerous. Also, by way of background, petitioner's registered mailing address on its deed with the Office of Property Assessment, with the City of Philadelphia in general, because there are multiple property owners, is and always has been and was at the time of the citations and the demolition, 984 Interval Avenue, Bronx, New York, 10459. Petitioner maintains that it was not provided notice of the imminently dangerous condition cited against the structure situated on its property, pursuant to the Philadelphia Property Maintenance Code PM-110.2 in the manner prescribed by the Administrative Code, Section 502.4. or in any other manner for that reason at its registered address prior to the demolition. Despite the fact that 45 days passed between the time that the property was cited as eminently dangerous and the time that the property was scheduled for demolition, petitioner received no notice of either the demolition or the eminently dangerous status that had been effectuating his properties. Additionally, petitioner did not receive any notice of the issuance of the demolition permit or the demolition at its registered address until at least April 16, 2019, 8 months after the demolition took place. At this point, I have some exhibits where I can show that, the address cited on the demolition permit is actually, as the mailing address for my client, for the petitioner, is actually listed as 2040 West Glenwood Avenue, which is the situs and the property that was demolished. The property that is not listed as his mailing address, which in fact is his mailing address, is the registered address of 984 Interval Avenue. Additionally, the city also offered at that September 30th, 2019 hearing, offered no proof that the property was in fact posted prior to the demolition. Petitioner filed a right to know request with the city, and I have the 2 documents that were received back pursuant to that right to know request. And those 2 documents are 2 return receipts, the first of which I've marked as petitioner's exhibit 2 and ends in 8740, has a USPS tracking number, and attached to that copy of the return receipt is the result for that USPS tracking number to match that particular card, which shows that the delivery of that item was not until April 16, 2019.
Are those the documents that you provided to
Yes.
our office?
Yes, for the copies.
It might be easier for us to follow them if
Okay,
when they're ready.
so then
Now that I didn't realize that you were describing the same
Right,
thing
so
that
then-
we
so then
are
I
going
can
to
just
see.
wait.
Just give me one moment. There were staples in the documents and the copy machine beat them up.
Okay, Okay, thank you. My
Just for
apologies for
clarification.
interrupting there, but
Just for clarification, is your client going to be testifying today?
They will not be. They were unable to make the hearing today. I thought that the hearing was to be in person. And I'm here at the DRB's office, at the DRB's offices. I didn't realize that he may have been able to join via Zoom. There was no indication of that on the notice that I received.
hi, Roxy. How are you? We're still in the meeting.
Thank you.
You're welcome. Okay. I'm just waiting them to come through from the computer. I just scanned them over. And then the city's document was so big, I thought I had sent it earlier, but it's just very large. Ms. Clark, do you have the petitioner's documents?
You're on mute.
I don't have it.
Okay, I'm gonna also include you on the email.
Sorry, I forgot I had this mess still around my face.
Okay, I just sent over the petitioner's documents to the board and council. Anybody get it?
I have it. Does everyone else have it?
I have it.
I don't have it. Oh, I have it.
Have
Okay.
it. Thank you.
Okay. I think we all have the document now. If you want to address it and call our attention to specific items within those pages, that would be appreciated.
Okay, so the first would be just to take a quick step back. The first document that I marked petitioner's exhibit 1. And basically it's just a printout showing the mailing address relating to the permit for the demolition as 2040 West Glenwood Avenue, which was the property that was demolished, and not in fact my client's registered address of 984 Interval Avenue, Bronx, New York. The second document marked petitioner exhibit 2 is a return, that is the first return receipt received from a right to know request, requesting proof of notice regarding any citations and a demolition concerning the property. This first return receipt ending in 8740, the USPS tracking number. In addition to this return receipt, I attached to this exhibit a copy of the printout from the USPS site showing the tracking delivery status of the item identified on the return receipt marked as petitioner's exhibit 2. And that document shows that the item attached to the return receipt was delivered on April 16th, 2019, which was about 8 months after the demolition took place. The second and final item I received back from my right to know request concerning proof of notice and or citation sent to my client regarding the demolition of his property is marked P3, Exhibit P3, and it is also a return receipt with a partial tracking number ending in 38. Clearly, it appears that this return receipt is dated September 23rd, 2019, which is over 1 year after the demolition took place. Because the image that I received from the city contained a tear to the bottom of the tracking number, there is no way to, or there's no way for me to actually be able to track this particular number. So I cannot with certainty, estimate as to when this particular item, whatever it may have been, would have been delivered to my client. The only thing that I can point out is that the date that is listed on this document that the city provided me is this September 23rd, 2019, which was over 1 year after the demolition took place. Based on the foregoing, it is my client's contention that the city didn't notify them, and at the very least did not notify them of the imminently dangerous status of the property. Had they done so, I'm certain that my client would have taken steps to try to remedy that. Also, in addition to the notice issues, other issues with the demolition lien include, and these can be pointed out pursuant to my exhibit marked Petitioner's Exhibit number 4, which is a notice to proceed. And the concern with this particular document is that part of it illustrates that part of the demolition lien costs imputed to the petitioner, to my client, concerned property belonging to another individual. And as a matter of fact, it specifically concerned a property that was at least one property removed from his own. If you will take a look at the notice to proceed, it says in the middle of the page, it says additional specifications, and it appears that my client was billed for a certain repair to a downspout, to unclog a drain at the rear of 2036 West Glenwood Avenue. The petitioner does not own that property. He was billed to replace a 30-foot section of a 6-foot high chain link fence at the rear of 236 West Glenwood Avenue. My client does not own that property. He was billed as part of this demolition lien to replace the sidewalk at 2036, 2038, and 2040, which is his property, but 2036 and 2038 were not his properties. And the bill was for $17,200, inclusive of those costs that did not affect his property.
I'm just going to object to everything that's been testified so far today. You've been testifying for your client who's not here. It's all hearsay, so you can continue, but at this point, I just wanted to note the objection.
What is hearsay exactly?
Everything that you said today.
An exhibit that was provided by the city.
You laid no foundation for anything.
We'll note it for the record. Thank you.
Note it for the record. I will say this though, to the city's concern, and also why I was asking if your client's going to be here. Were these issues brought up in the master's level hearing where you had firsthand knowledge or you were witness to that?
The issues were brought up in the master hearing.
Okay.
And, there is.
Was your client represented at the master's hearing?
But yeah. Was your client represented at the master's hearing?
Yeah, I represented him, yeah.
That's why I'm asking this question. So these issues were raised at the master's hearing where you had firsthand knowledge to what you're talking about today, correct?
Yeah.
Okay.
Yeah.
I know that won't assuage the city's objection. I'm just trying to make sure that what you're testifying to, that you at least can say firsthand knowledge that these are the arguments that he wanted you to make because he's not here, or he or she is not here at this point.
Yes. Yes. And if it is absolutely necessary that they be here, then I would request a short continuance to try to get another date to have him join us if it is absolutely necessary. But I feel that, you know, the issues are pretty clear on its face. I mean, all we've asked for is some proof that he was actually served notice of the citation that was issued against him prior to the demolition. That should be pretty self-explanatory. At the first master hearing that we had in 2019, we had a city employee that testified, and I believe it was Mr. Robakowski that testified that yes, notice would have been sent in the usual manner, but they didn't have any particular notice relating to this particular property and these particular citations and demolitions. And when I did a right to know request requesting the same, I was not provided with anything that showed that notice was ever actually sent.
Okay, so your concerns or the reason why you're here today is that you're arguing that there was not sufficient notice for the property at 2040 West Glenwood Avenue prior to the demolition. And you're also arguing that your client does not own 2036 Glenwood Avenue and you're disputing the bill.
438.
What is it, 20 what?
There was 2036 and 2038 that were
Okay.
referenced in the testimony before that were
Okay,
not
so-
owned by.
38.
So those are the 2 points of why we're here today.
Right, and it is what is referenced, well, there's actually a third, and I'll bring that up in 1 second, but it's actually referenced on the notice to proceed, on the permits, on everything that the city, you know, on public records that the city has, what exactly the specifications were that were included in this bill. But the third and final issue that I had is basically that, in addition to the demolition, petitioner was also assessed a $17,000 waterproofing and purging bill for neighboring properties allegedly incident to the demolition. We had a TRB hearing on the waterproofing and purging on February 10th, 2020. The hearing concerned the same waterproofing and purging issue. This before we even had our hearing, the city, and I believe it was Mr. Rabakowski, agreed to completely abate the demolition costs without a hearing. The lien was then cleared. Okay, so this was February 10th, 2020. Several months thereafter, my client contacts me and says, hey, I just noticed that the waterproofing and the demolition lien is cleared, and I just noticed that the waterproofing and purging bill is still showing up against me. So I contacted agency receivables or L&I, I'm not sure which one. And as soon as I contacted them, the waterproofing and purging lien was removed and the demolition lien was reinstated, right? And I believe this lien, the smaller lien was reinstated as well. I'm not sure, but I know that the demolition lien was reinstated. So then,
For clarification, I also have some information about that. That was also
That would be
given the
great.
docket number. I'm sorry?
that would be great. I would
Yeah.
welcome that.
I have a docket number of 26 NUMERZZ 6869. And the tax review board granted that petition on 2/10/2020. That's what the tax review board has in its records in regards to that particular case.
Right, and basically that ruling, I know that the case ID number, I guess, corresponds to the waterproofing and purging, but the agreement and what the city proposed was a complete abatement of the demolition lien. And then that's what they had done. And then for some reason, several months later, they reinstated it.
Who is
So
they in that, who reinstated it?
I guess it would be agency receivables or the Department of Licenses and Inspections. I contacted either one. About.
Mhm.
but,
For clarification, are we talking about the cases that are listed today, or are we talking about a completely separate case?
It was a completely separate case.
Okay.
That wiped out the lien that is at issue today.
Okay,
That's where I am with it. I am.
so
this could
It was
be
a
about-
master level hearing.
Yes,
The master level hearing was
Was
on
for
that,
which
on that
bill?
particular matter. Was
Which,
granted
which matter?
on the water part.
Okay, waterproofing or,
Yeah, that was granted by the board, by the master level on 2/10/2020.
Okay, so it is still then the demolition and the sealing of a lateral.
Yes, those are the only two matters
But
we have.
today, not that other, the water sealing and whatever. Okay,
The
Right.
city did not
And
appeal
numbers-
that matter.
okay. So,
But if I may, at that hearing, prior to the hearing, we didn't even have a hearing. We just showed up to the masters and the city agreed to waive all the demolition costs.
okay, well, clearly that,
Yeah.
we're here because that wasn't
Yeah.
the case.
Well,
So,
they had done that. They had cleared it, right, as they said they were going to do.
okay, well, we're gonna have to hear from them as
Okay.
to, you know, how that.
So that's my third issue.
But if I could ask just some preliminary questions, it might help us kind of move this along. Can you tell me when your clients purchased this property?
Yes, I can. Yes, it was in 2016. December of
2016. And what kind of property was this?
I believe it was a residential. I think they had purchased it from a sheriff's sale. It
It's
had-
residential. I pulled it,
Okay,
Paula.
thank you.
It had been boarded, I believe, when they purchased it.
Okay, so it was vacant when they purchased it.
It was.
It
purchased from a
continued to be
sheriff's sale.
vacant.
Mhm.
And did your clients take out a vacant property license with the Department of L&I at any time?
I'm not sure.
Okay. So was there some other way that you believe the city should have known of the off-site mailing address?
Yes, because that was the address that was their registered address on their deed, on their transfer tax certificates, on the OPA website, and for other properties that they own within the city of
Okay,
Philadelphia.
but they didn't specifically inform L&I, fill out a vacant property license application that you know of that would have given them an off-site mailing address for this property?
Not that I am aware of for this
Okay.
particular property, not that they didn't do it, I just don't know if they did or did not. But I do know, as I said, that per the Office of Property Assessment website, which is a city agency, which keeps track of the city's properties, that the registered address for this property is 984 Interval Avenue.
Okay, got it. Thank you. Those were my questions initially. Thanks, Nancy.
Did you have anything else before we turn to the city?
No, I do not.
Okay,
Thank you.
let's hear from the city then on this matter.
The city is prepared to proceed with this case in chief. If that's okay.
I'm
with
sorry. Say that again?
The city is prepared to proceed with this case in chief, if that's okay with the board.
That was what I was asking you to do.
Okay, so the city will call Inspector Rabakowski.
He's already been sworn.
Good afternoon, Inspector Rabakowski. Can you state your occupation for the board as well as your position and how long you've been in that role briefly?
For the past 6 months roughly, I've been assigned as a supervisor for contractual compliance, assigned to contractual services unit. Prior to that, I was an inspector with the same unit, and I am and continue to be the court liaison or one of them for the department.
Okay, and are you familiar with the property located at 2040 West Glenwood Avenue?
Yes,
And how are you familiar with that property?
through case record and also preparing for the tax review board master hearing as well.
And have you had an opportunity to review the L&I records for this property?
Yes.
At this time, I'm going to share my screen with members of the board. At this time, I'm referring the members of the board as well as counsel to defendant to what has been previously marked as City Exhibit 2. I'm just going to scroll through it briefly. Inspector Rabakowski, I'm showing you what has been previously marked as City Exhibit 2. Do you recognize it?
Yes.
Okay, what is it?
It is a notice of violation indicating the property as eminently dangerous. This notice is dated August 1st of 2018. It is referencing case number 647348, and it is referencing the property at 2040 West Glenwood Avenue. It was mailed out to Five Brothers LLC, who is the recorded owner of the property. And it was sent to 984 Interval Avenue, Bronx, New York, 10459.
Thank you. And is this document kept in the ordinary course of business?
Yes.
And what were the violations specifically at this property?
The violations were for the interior flooring assemblies were partially collapsed. The property was vacant and unsecured and open to trespass. And it was declared as eminently dangerous by Inspector Brooks.
And briefly, can you describe what an eminently dangerous property is?
Eminently dangerous property is just that, is that it is in a state of structural distress in that it opposes immediate threat to the adjoining properties or the public at large.
And prior to the notice of violation that was sent to the defendant's home address, which is 984 Interval Avenue, Bronx, New York, were there any other notices sent or any other postings sent to the property?
Actually, this property was declared as unsafe following an inspection that took place in July 20th of 2018, where the property was declared as unsafe and posted at that time. And then the inspector went back out to the property on August 1st and posted the property and declared the property as eminently dangerous following that inspection and issued this case accordingly.
And can a person appeal following the issuance of a notice of violation?
So on this page for the document, there is language to the right of the appeal. It gives the owner of the property the right to appeal the violation within 5 days of receiving this notice. Also, the posting of the property also has the same type of language written on that posting.
At this time, I'm going to share with members of the board City's Exhibit 3. Inspector Rabikowski, I am now showing you what has been previously marked as City's Exhibit 3. Do you recognize it?
Yes.
What is this?
These were photographs that were taken of the property in July of 2018, where it is posted as unsafe. The responding inspector was Inspector John Madres. It is for 2040 West Glenwood Avenue, indicating the property as unsafe. It details the places of violation are the sidewall, rear wall of the sidewall and exterior wall of the property.
And does this photograph fairly and accurately depict the scene on the date and time in question?
Yes.
Where is this posting in relation to the property? Is this the front, the back, the side?
This is posted to the front of the property.
Okay, I'm going to scroll down the same exhibit. It's a series of photos to another picture. Inspector Rabikowski, what is this picture?
This is a picture in the normal case of business. It was taken of the property, the rear side wall. You can see that there is a collapse or a hole in that side wall. Basically, it was spelled out on the notice. It is open to access, meaning that somebody could crawl right through that hole and get into the property and do heaven knows what inside a property that has been declared as eminently dangerous.
Inspector Rabikowski, could you explain this picture as well? What are we looking at?
This is another photograph of the property. These photos were actually taken at the time the property was placed out to bid. At the time the property was placed to bid for demolition.
I'm going to scroll down to another photo. Can you explain what we are looking at in this particular photo?
So when the city placed it out to bid for demolition, they saw damage to the adjoining fence. And part of the bid process was to repair the side fence of that property along with making the repairs and the demolition of the property.
And lastly, Inspector Rabikowski, what are we looking at in this photo?
So this is essentially the final photograph that is taken by the area inspector. This photograph was taken after the demolition and the work associated with the bid process. This includes the complete demolition of the subject premise, the work alongside in the vacant lot next to it, the replacement of that fence, and the replacement of the sidewalk in front of the subject premise.
And based off of the photos that I showed you, and from your knowledge and expertise, did any of these photos present any potential issues for the public, the neighbors, citizens of Philadelphia, as it pertains to this property and the condition it was in?
So if you could scroll back to when the property was visible, or before the demolition, that you could go to that photo, just that one. So if you look at this photograph was taken August 15th of 2018. This photograph shows that the property itself, it shows the two postings on the property. The first one is the orange one, or the faded or yellowed posting. That's the unsafe. And then right on top of that is the other posting where the property was declared as eminently dangerous. I'd also draw your attention to the red X that is affixed to the front of this property. That is a red X, basically that if something is going on with this property and first responders have to go to this property and a fire is occurring, let's say a fire is occurring at this property, it is to let the firefighter or the responding emergency personnel to know that this is a structurally compromised building and not to enter it. Basically fight the fire from outside the property, surround and drown the property until the fire is extinguished. I'd also draw your attention to this property that there is a real estate sign or a for sale sign on the property, as this was a vacant property and the intentions were to sell this property instead of making it safe for the general public.
This time I want to shift your attention to the cost of the abatement. So I'm referring the board and council to defendant to what has been previously marked as City Exhibit 4. It's a series of documents, the same document. I'm going to go to that last page. I'm going to zoom in so hopefully you can see. Inspector Rybakowski, I am showing you what has been previously marked as City's Exhibit 4. Do you recognize it?
Yes.
Okay, what is it?
This is the bid process. We received 2 bids for the demolition of this property. The 2 bids were from USA Environmental, but it's marked as USA, and then Manguel Demolition. The winning bid was for $17,200 for the demolition and the associated work to this property.
And is this document kept in the ordinary course of business?
Yes.
And you already stated the City of Philadelphia ultimately went with USA's bid for $17,200, correct?
Correct.
Are there any additional fees that are coupled with the abatement price that we see here for $17,200?
Once we receive the invoice from the contractor and payment is approved in that the demolition is completed, the associated area inspector will fill out what is commonly or departmentally referred to as a payout slip, basically approving paying to the contractor. Once that is processed, then a invoice is processed and sent to the owner of record. That invoice also includes a 21% administrative fee.
At this time, I am referring the board and council to the defendant to what has been previously marked as City's Exhibit 5. Inspector Rybakowski, I'm showing you what has been marked as City's Exhibit 5. Do you recognize it?
Yes.
Okay, what is it?
This is the invoice sent to the owner of record, indicating that this is a demolition, that a demolition has occurred at the property. The subject property was 2040 West Glenwood Avenue, and the cost associated with that demolition, including the 21% administrative fee, is $20,812.
Again, is this document kept in the ordinary course of business?
Yes.
And what address was this document sent to?
5 Brothers LLC, 984 Interval Avenue, Bronx, New York, 10459.
And was this bill sent before or after the abatement process was completed?
After.
And again, for that number, $20,812.
Correct.
What is that including?
That is including the 21% administrative fee.
1 second, I'm going to stop sharing my screen. Inspector Rybakowski, to your knowledge, was the City of Philadelphia billed for this cost?
Yes.
And to your knowledge, was the City of Philadelphia reimbursed for the cost of abatement for the property at 2040 West Glenwood Avenue.
When you say reimbursed, I'm not sure what question. that is.
Did the defendant ever pay for that cost of abatement?
No.
For the no further questions at this time for Inspector Rabakowski. And at this time, I would like to request that all evidence presented to the board be admitted into evidence.
Could I ask Mr. Rubikowski a question or two at this point, Nancy?
Yes, please go ahead. I was just going to ask for that.
Mr. Rubikowski, can you tell us from any notes in the system whether there was any contact by the petitioners? Did they ever respond to any notice or billing or whatever that you can see?
Other than the filing of the appeal to the tax review board at the master's hearing prior to this hearing, and the continuance that the continued hearing of September 3rd, 2020, we had no contact with the owner.
Thank you. And Ms. Clark, we have two bills that were read out at the beginning. Is there going to be a separate presentation as to sealing of the lateral?
We were going to follow up with questions regarding the sealing of the lateral for the total amount that was read off by Inspector Wade. Just as a normal course of business, we were just going to follow up with that question.
Okay.
Yeah.
And okay, that's it for right now.
Are there any other questions for Mr.
Yes,
Rabakowski or?
Madam Chair, I would love to have the opportunity to cross-examine him. I would like to say that I just received this document from the city. I had not seen any of these exhibits or anything that's contained in this document before today. I would like to ask Mr. Rabakowski a couple of questions, and I don't have access to that document online, so I would ask the city attorney if she would cordially maybe bring the document up for me, and maybe we can go to exhibit number 2, which I believe was.
Ms. Clark, can you bring that up? Thank you.
Thank you so much.
One second.
You said it was exhibit 2 that you were looking for?
I believe so. It just went by so quickly, and like I said, not having it, mine was all out of order, so I don't.
What exactly was the document?
It was the letter to, let's put the alleged letter to my client here, marking the property and anything.
The violation notice?
Yes, the violation notice.
All right, this looks like it is it.
Okay. And Mr. Rabakowski, can I ask you a few questions about this document?
Sure.
Okay. And the first is, so typically when these documents are mailed, they're mailed first-class mail, is that correct?
They are actually, there is 3 ways that a owner of record is made aware that there is a violation or an issue with their property. The number 1 is that we post the property. Number 2 is we send out a notice of violation, first-class mailing, and number 3 is we send out 1 certified mail.
Certified. And would you happen to have a return receipt? Having looked through the file, did you notice a return receipt for this particular mailing?
Not for this one.
No. And would there have been any particular reason as to why this letter would not have been included in a right to know request, requesting any notices that would have been sent to my client concerning this eminently dangerous status or demolition?
That's actually a question for your client, because they signed for the demolition bill and signed for the lateral bill. So, and it was sent to the same address. So why didn't they accept service on the original? I can't answer.
Right, but what I'm saying is, would one of these violation letters typically be included in a right to know request requesting the same?
Object to that because
He wouldn't be able to answer that question. He's not in the right to know department of the city of Philadelphia. So we'd have to move on from that one.
Can you repeat that? I'm sorry, I didn't hear what you said.
He wouldn't be able to answer that question. He doesn't work in the right to know department of the city of Philadelphia. I think you would need to cross-examine somebody from that department in order to get that answer to that question.
Okay. Now, is this, let me take a step back here. Okay, I'd like to move on. Can we go to Exhibit 3? Which I believe was the picture of the downed fence. Further down. Thank you so much, Council. If you could just keep going. So that picture's fine. So before Mr. Rabakowski, I believe you testified that the bid for this demolition included the cost to fix that fence. Is that correct?
Yes.
And can you explain why that bid would have included the cost to repair that fence when that fence does not touch and concern my client's properties?
Because of it being a vacant property and the lot next to this property was also a vacant property. And the fence itself needed to be repaired. The city went ahead and added it to the bid price for the contractor while they were on location to repair this fence.
But just because the city needed this fence repaired, and it probably should have been repaired, should my client be responsible for paying that bill? Or the portion of the bill that is effectively, for repair of a fence that does not touch and concern his own, or a drain pipe that doesn't touch and concern his own, and he's had no effect on, and the sidewalk that he has no effect on?
That's what brings us to today's hearing.
Would you say that again, please?
I said, that's what brings us to today's hearing.
Oh, okay. I'm sorry. I didn't quite catch what you said.
Okay, well, I think that's all I have, Mr. Rabakowski. Thank you for your time.
You're
Okay.
welcome.
Does that conclude the city's presentation?
No, I have a few questions. Let me just stop sharing my screen.
Okay. Please go ahead.
So just to redirect, Inspector Rabakowski, Defense Counsel alluded to a draining system and the payment being included for that final bill that we see for 2040 West Glenwood Avenue. Can you speak to that sealing of the lateral and why that was necessary to couple along with the demolition process?
So along with the demolition, the city contacts a subcontractor or a plumber. The contractor or the plumber is contracted to seal the lateral. And what we mean by seal the lateral is basically the sewer line from the property is basically sealed so that the dirt or debris doesn't wash into the sewer system or the water department. It also prevents the active infestation or wildlife that neighbors the sewer to come up into that vacant lot.
And is the sealing of the lateral a normal procedure for cases that are involved demolishing the building?
I would say with about 98% of all the demolitions that the city performs, a sealing of the lateral is also required on that property.
Okay, no further questions at this time.
Okay, any board members have questions of either side?
Question. Counsel for the petitioner, if you don't know, you can just say you don't know. Your client acquired this property back in 2016? I believe that's what the testimony was today.
December of 2016.
Did your client ever go to this property before December? Did your client ever visit this property? That's question one.
I am really.
You don't know.
aware.
Okay.
I'm not aware. Either way, I couldn't tell you.
Okay, and then I have a question for Mr. Rybakowski, always butchering it. I apologize every time. The notice that counsel for the petition had you pull up, that had the city pull up, the notice violation. You see the address on there denotes the Bronx, New York address.
Correct.
Can you testify today that that is the actual notice that was sent?
Yes.
Okay, thank you. No further questions.
If there are no other questions, I think we should be stepping aside as a board to see what our
Oh, I have
issues are
one other
actually-
question, Nancy. I'm sorry. One
Sure,
further.
that's correct.
Mikowski, is there a bill that breaks down the actual costs associated with this demolition so that we could see the cost of the fence, the cost of the demolition, the cost of the stucco, and everything that totals up to that 17,200.
It's
Unless,
about 20,000 altogether.
so typically, the only time we receive a invoice with our breakdown is if we do a site improvement. So if we call for an emergency, and not in this case, but if we call for one of our demolition contractors to go out to an emergency location, they will provide a breakdown, how many laborers, how many trucks, how many, and they'll break down how many hours they were on location. For this being a bid, they just go with a price and submit that price into the department. We take the lower price.
Okay, thank you. I have no other questions.
Okay, if there are no other questions, the board's going to step aside and see if we can reach a decision.
Madam Chair, can I ask Mr. Rabakowski one more question on re-examine?
I'm sorry, I couldn't hear
I
you.
would just like to ask Mr. Rabakowski one more question in relation to the question that Ms. Weiss just asked regarding if there is any way, basically, at this point, that we can sort of break down what the individual costs were for each of the things that were included in this bid. Like what was the cost for the downspout? What was the cost for the sidewalk? What was the cost for the fence? What was the cost for the demolition?
That's what he just testified to that, I believe, it was the same question. And he said that when they take the bids, well, I'll let him repeat it, but he basically answered that question just a moment ago.
Right, I'm just trying to figure out if there's a way to ascertain that now. That
Oh,
would be
to get it now.
Right, like after the fact, obviously.
Okay.
Go back in
I-
time.
Mr. Rabakowski?
Unless the contractor was kind enough to provide a invoice to the department with a breakdown, which they typically don't. I don't have that document in front of me. I do know that the city was charged 17,000 as Ms. Clark's exhibit, 17,000 and change for the demolition of this property.
Okay.
Should we go back?
Let's step aside.
Everybody can just sit tight. Nancy, you're on mute, but you're back.
There we go. I think we're back. The board's reached some decisions. I'm going to start out and then ask my fellow board members to chime in and make sure I cover everything. But it's our decision to abate the interest and the administrative costs and to ask that arrangements for payment on the principal of $17,200 be made within 30 days. Did I miss anything there on the basic?
No, that's just on docket that ends in 9284, the demolition.
Okay, thank you for adding that. And on the other docket number that ends in, what is it?
6930.
9284, or is it 92?
6930.
6930.
I was getting them reversed. And we are honoring that petition. Is that correct?
Granting that petition.
Granting. I used honoring, granting the petition. My apologies. I used the wrong word. We're granting that petition. And
appeal rights?
I'm sorry?
Appeal rights?
Oh, yeah. I was just going to ask if there were any questions first, but basically you'll get a letter from us that spells out our decisions on both docket numbers. Both sides have the right to appeal to the Court of Common Pleas within 30 days of the date of our letter. But I'm going to assume from the moment that neither side is going to choose to appeal. And should that be the case, then the amounts that were being abated would be taken off the record, and you should receive a revised bill for this principal amount that would be due and make payment arrangements for that within 30 days. Any
I
questions?
concur with that, Nancy.
Okay, Dominique? You're on mute.
You're on mute.
Dominic Ford concurs with that ruling as well.
Okay, and as stating, the one stating the numbers, Nancy Camerodiner concurs. Any questions? If not, this being the last item on our agenda, thank you all for your patience today, and this hearing is adjourned.
Thank you, everyone. Have a
Well, good evening, everybody. Bye.
Bye now.
What a day.
Anyhow.